MSc Appeal number 638, 2017 stands allowed. And MSc Appeal number 469, 2017 stands dismissed.
Obliged, Lordship.
Item number 37, WPC 4810 of 2023.
Petition allowed. Review and order set aside any clause.
Obliged.
That was, Miller, item 16. Please pardon me, I have taken consent from the responding Miller. So it will be taken next week, I have some problem.
Oh, how many days?
Miller. Item 16. So my prayer, Miller, it may be taken on Miller the 19,
19th of this month.
my lord. 1911.
On 21st November.
But on the prayer being made by Mr. A. Rosit, learned counsel for the petition of which consent from the other side. The matter stands adjourned to be listed on 21st of November. Yes.
May I please, I recommend for listing and for admission, madam. It was last posted on 3/9, madam.
When
Okay.
to what?
The list provincial is no service.
When?
Madam, next week.
On 24th.
Obliged.
May I please, Lordship? Lordship, I beg to mention a writ petition for listing, Lordship, on Wednesday, Lordship. The matter was last listed in the month of July, Lordship, and it is regarding
No, Wednesday may not be possible. Take a date from him.
On 14th, Friday.
obliged, Lordship.
I'm going for listing of this matter for admission, madam. Possible on Wednesday.
Wednesday,
On 19th, the next Wednesday, 19th
Lordship.
November.
Lordship, I have another prayer for a contempt petition, Lordship. Any date subject to the convenience of Lordship, Lordship.
28th November.
Obliged, Lordship.
My lord, I beg to mention about listing the case, my lord, the petitioner declared in January 24. And last occasion, they said that they have forwarded his name, but 2 years now on, it's not, so it may be listed, my lord, pension is not,
when?
my lord, any next week,
On 24th November.
20, sir.
May I please, Lordship? Lordship, I beg for listing few read petition, Lordship, in admission column, Lordship.
When?
Matter part, Lordship, 14 this month.
14th may not be possible.
On 21st November.
Blessed.
Please, Lordship, my prayer is for listing Lordship admission matter regarding provincialization of service of the petitioner, Lordship.
When?
Next week, Lordship.
Okay.
On 26th November.
May it please your lordship, I beg to mention for listing of writ petition.
When?
This week, any date or next,
This week.
this week, any date or next week,
On
Next week.
14th. 14th Friday.
14th, right?
Yes.
Lordship, item number 39 and 40 of part 2 hearing list, Lordship. Only
39 and
part 2 hearing list.
that list is not before this court.
But only two, Lordship.
This doesn't come to the court. Protect the back.
May I please,
Obliged,
I
Lordship.
beg to mention item number 32 of today's list.
Item
Madam,
number
32. Madam, may I please, madam, this matter may taken after motion matters, madam.
Okay, all right.
Obliged.
Item for personal appearance, item number 33 for orders.
Madam, find the sanction order at second page, madam. Sanction of the area salary. The earlier order was recalled, my lord. That order, my lord, will find at the fourth page.
But
I have informed the advocate for the petitioner, my lord.
You inform,
Yes, my lord. He has a motion matter in next court, my lord. So he is coming, my lord. So my lord, may take it after some time,
okay then.
after 5 minutes, my lord.
Item number 1,
May I please, Your Honor.
Yes.
See, the relevant portion of the order is page number 24. This is lordship order asked for regularization, but till date they have not initiated any process.
Heard, Mr.
AU only.
Learned counsel for the petition. This petition under section 12 of the Contempt of Court Act 1970. Either particular 215 of the Constitution. And the contempt of court in the Guwahati High Court to 1947 is deferred by the petitioner for willful and deliberate violation of the order dated 8/5/5 passed by this court in the petition number 5254/8 of 2019. Where is the petition? It's by some record and also where is the order dated 8/5/2025 passed in the petition. Issue notice to the petitioner returnable in for it. Step be taken by registered court with ADM October 8 of this after 4 weeks.
item 2,
May I please, Your Lordship? Ma'am, this is the contempt petition, my lord. Order is at page 35. Lordship passes as well, my lord. From gate 4 to gate 3. Permission.
But Mr. Peter Luther learned counsel for the petition. It's petition. It's
May I please, my lord? Reaction was issued from the respondent number 2, page 38, para 9. So only notice may go to the respondent number 2.
under section 12 of the Contempt of Court. As a faithful date with. Section 216 of the. The rule thereafter is deferred by the petitioner for willful disobedience of the order of this case is in 9/1/2025. Passed in publication of part 8E8. There is a petition in the document. Second record at for the order dated 9/1/2025 passed in publication. That notice be issued to the concept or returnable in court. Step be taken by registered court with variance of within a week. Direction was issued to only respondent number 2.
My lord,
So notice has to go only respondent number 2.
my lord, my lord. Page 38, para 9.
Although no notice is required to be issued to the rest of the respondent. That is it. List after 4 weeks.
item number 3,
May it please, Your Lordship. Lordship, the petitioner approaches honorable court seeking payment of arrear salary and non-payment of his earned leave, wrong calculation of earned leave, operating part of the order Rochester will find page 17, para 14. May I read it, Your Lordship?
Not
Yes, sir. Para 17, page 14.
Third, Mr. K. Monto, learned at Computer. It's under Article 215 of the Constitution of India, dated 11 and 12 of the 21. And Rule 3 and 4 of the Contempt of Court. I go to 197. Preferred by the petitioner for willful and deliberate violation of the order dated 17/6/2025. Passed by this court in WBC number 5796 of 2026. And also the order dated 14/7/2025, passed in IS civil number 141. That notice is to the returnable for the be taken by registered for the ATM for the usual process in a return. List of for its
Deeply obliged.
Item number 4,
May I please? At last occasion, I was adjourned.
Thank you, please, Your Lordship. Instruction received in this regard, Your Lordship, that re-verification report from the authority of Chaudhry Charan Singh University from the B.Ed degree that petitioner has obtained is still awaited, Your Lordship.
That instruction was submitted last occasion also. The submission.
7. Your Lordship, I would like to place it, Your Lordship. The ongoing process of re-verification is going on regarding the documents, Your Lordship, as there is some doubt regarding the genuinity of the certificate.
I take your lordship to page number 36.
I have given both the report, Your Lordship, received, Your Lordship, earlier one and the present one, that is 7/11/2025.
Page number 36, my lord, your lordship will find this is the NCT recognition of the college from where the petitioner passed the B.Ed degree. That was not placed on the day of interview. That is why they have put the doubt.
And moreover, Your Lordship, including the mode of obtaining the degree, that is also, Your Lordship, needed to verify, Your Lordship. Earlier report I already submitted, Your Lordship, which is backend verification report from the university is awaited. And this is the first latest instruction, Your Lordship, received on dated 7/11/2025. As letter has already been issued, Your Lordship, sent, Your Lordship, to Chaudhry Charan Singh University, that is on Meerut, Ramgarhi, Meerut, UP.
My submission is that, my lord, your lordship may issue notice in this case and me please to, my lord, give direction that his name may not be excluded from the purview of consideration till subject to outcome of the verification. Even if he is appointed, my lord, he may be terminated if the certificate is doubtful.
Certificate has
But the
not
process
been
of
submitted.
appointment, just a minute. But the process of appointment, once it is over, then he cannot come into.
let the report come through, we'll consider your case. Third, Mr. P. Purpose the current for the petition. Either the next thing of the secondary education department. Thus, learned standing from the respondent in secondary education department of its state. Verification with respect of the candidates or results have been withdrawn. This is going on and a report has been pulled also from the authority of Chaudhry Charan Singh University, Meerut, regarding the B.Ed degree of the and the same is still awaited. And as such, the price for listing the matter after 2 weeks,
Yes, Your Lord.
after 2 weeks, there is according to law, after 2 weeks.
My lord, it may come on the date, my lord. Complaint.
1, 2, and 4. Number 5. DP obliged. Thank you.
May it please, man. My lord, the respondent Guwahati University were to place the instructions today, my lord, regarding my subsistence allowance and the 4 KVPs, my lord.
Lordship, my senior is coming, so kindly timing the matter. Let him come.
Yes, yes, ma'am. Yes, ma'am. Deeply obliged.
Item 6,
May please, your lord. Matter relates to the compassionate appointment, lordship. Petitioner further expired in the year 2017, February 21st, lordship. Thereafter, petitioner prepared the application within the specified time. Accordingly, her application also placed before the DLC. Lordship, kindly the minute page 26. This is the relevant part, but her application was till date not considered or rejected, lordship. Just they have deferred the matter to place on the next DLC. Accordingly, my simple prayer before your lordship to place the application of the petitioner before the DLC. This is my prayer only.
Mr. Devdi? Yes, your lordship. Lordship, the matter relates to 2017, your lordship. So in taking that into account, the petitioner may be, he may be provided an opportunity so that his case be placed in the next years.
Simple prayer only. Mr. ABT Hawk, Current Council of the Current Assistant of Home. You are appearing for Mr. David. Respondent number. And I have for the respondent number 4. Then Mr. Yusuf for respondent number 4. Petition under Article 226 of the Constitution of India, the petitioner has tried for its direction. To the respondent of purpose. To place the application of the petitioner before the district level committee. The of Current Council for the petitioner submitted the father of the petitioner was working as assistant teacher model higher secondary school. And he died in harness on 1st of February 2017, leaving behind the petitioner and his wife. Therefore, the petitioner being the daughter and having possessed the requisite qualification, filed an application on 3/5/2017 along with biodata for completion and appointment. Thereafter, by minutes of meeting dated 4/3/2017 of the district level committee, the application of the petitioner on completion is down to a therefore, for consideration of the next DLC, but till date, the same application. The said application has not been placed before the district level committee for consideration. So further submits that this application may be disposed of, that is motion itself, by directing the respondent authority to place the same before the district level. It's a deputy current standing council for the respondent authority submits the case no objection. In the event of directing the respondent authority to place the matter before the DLP. Accordingly, taking note of the submission of current counsel for both the parties and also considering the facts and circumstances on the record, the court is disposed of the by directing the respondent authority. The respondent number 3. Who will place the matter before the DLC? DLC district level committee will. Who will place? School inspector, lordship. Respondent number 4. Respondent number 4 is directed, directing the respondent number 4 to place the application of the petitioner before the district level. Next, veritable district level. in terms of its the petition stands disposed of, that is motion.
Item number 7.
Item number 7, my lord, I'm praying for some more time to obtain the instruction.
Part is that
I do.
I don't think learning conflict for the and they cut out learn extension of the eliminated the part. It's the pattern it's that you may take some more time to carry it along. That's less than a third.
After 2 weeks, my lord. 2 weeks, my lord.
2 weeks.
Yes.
After
Obliged, lordship.
Item 8.
Please, your lordship. We are- I'm a headmaster of this school, Melons.
Hmm.
Earlier, we were attached to, for examination center, we were attached with the Dharmapur High School. Now we are attached with the Kadamtala Higher Secondary School. Now, Melons, what's happening is that the students,
but first you tell me who are you?
I am the headmaster of Dharmapur High School.
Do you have any absolute right to conduct the examination in each and every year?
Yeah, I'm representing on behalf of, I'm representing on behalf of the school, Melons.
Student,
On behalf of the students,
where is the authority letter?
we don't have the authority letter, we don't have the authority letter.
Then
But even for the consideration, your lordship will consider on the humanitarian grounds that they are the students, they are having some problem. They are since class 10, the examination center has been changed.
okay. Yes, we will take up the matter. There are several matters. We will take up all the matters together after some time.
Okay, sir.
Item number 9.
May I please, your lordship? My lordship, petition pertaining to lordship area salary of the petitioner lordship. My lordship, petitioner was the lordship initially appointed in the year of 1983 lordship in a Bensar LP school lordship. Then lordship, the school was luckily provincialized in the year lordship 2015 lordship. And the effect was given lordship from 1/1/2013. Then the lordship, Honorable lordship, kindly see the page 22 annexure 3. This is the provincialization of the service of the petitioner lordship.
Your service has been provincialized with effect from 1st of January 2013.
22 April 2015 lordship, and effect was given 1/1/2013 lordship. I am reading the letter.
During that period, you have not been given the area salary.
Lordship, and the lordship thereafter lordship, kindly see page 24 annexure 4 lordship. This is the communication made by the block elementary education officer to the district elementary education Borpeta lordship. Page 24 lordship. And thereafter lordship, the district elementary education officer Borpeta lordship made a communication lordship to the director lordship education department lordship, page 26 annexure 5. Thereafter lordship, the block elementary education officer lordship Mondia block, again the lordship made a communication lordship to the district elementary education officer with a statement of the salary, that is page 44 annexure 7 lordship. Annexure 7 page 44 lordship. And the statement of the monthly salary of the petitioner, that is page 45 lordship. Thereafter, Lordship, finally, Lordship, Director, Lordship, Direct Elementary Education Officer made a communication to the government, that is page 49 annexure 9, Lordship. Now, my lord, my submission is that, my lord, my limited submission is that, Lordship, my learned event may be directed, Lordship, to get the instruction and the Lordship, to get the non-dual certificate from the Treasury, Lordship, from the Treasury Borpeta, Lordship. And that may be effective, Lordship. Non-dual certificate, yes, that is a Lordship to get from the Treasury officer, Lordship, regarding the dual or non-dual, Lordship, of the salary of the petitioner, Lordship.
Yes, madam, you obtain inspection in.
No, my lord, can you notice may be issued, madam? Notice may be issued.
My lord, other.
Without issuing a notice, it is very difficult for us to place it.
No, Lordship, then Lordship, it will take, Lordship, already petitioner has got retirement, Lordship, in the year 2020, Lordship kindly takes, see, Lordship, for a moment, it's a 38, Lordship. Already petitioner, Lordship, has got a retired, Lordship, from his service on superannuation, Lordship. Lordship petitioner having, Lordship, pensionary benefit, Lordship, because,
My lord, can you
Lordship,
notice
kindly
may
see,
be
it's a 38.
Madam, you see, the director for elementary education has written a letter in the year 2019 to the commissioner and secretary.
And onward communication is a matter, Lordship, my lord.
My lord,
Onward
that
communication is a matter.
verify, my lord. So
You-
kindly notice may be
You
issued.
obtained inspection about the status of this letter.
Yes, Lordship.
My lord,
What is the difficult, Lordship, to get the instruction, Lordship? Otherwise, if Lordship, Lordship issue notice, then it will take,
First, you obtain inspection.
yes, Lordship. It will take 2 years, 3 years and indefinite period.
This. And token for next standing council for the respondent of her case. The petitioner here in track two is doing directly to the respondent of her. More particularly, the respondent number 3 to relate the area salary of the petitioner with effect from 1/1/2030 to 21/4/2016. For a sum of rupees 5,60,000. Mr. Ali Sardak, protocol of the petitioner submits that the petitioner was appointed on 1983 as the headmaster of 14 Mohammadi Zahanelgaon, Mahmoud Hussain Cancer Primary School. And he joined on 1/3/1983. And thereafter, the school was provincialized by order dated 22nd of April 2015 by the Director of Electric. And the service of the petitioner was provincial. And thereafter, the petitioner discharged his duties. And while he was in service, he made court. To discharge his duty with utmost sincerity and to the satisfaction of all concerned authorities, but unfortunately, the petitioner has not been given his area salary with effect from 1/1/2013 to 4/15. And the petitioner has filed one representation on
3823.
his number
Page, Lordship, 52, Lordship. Annexure 11, Lordship. 5925.
to the block elementary education officer. on 15/9/2025, but the same failed to evoke any response. Mr. Ali of further submits that on earlier occasion also, the petitioner has filed one representation to the block elementary education officer. And the block elementary education officer has forwarded the same to the director, elementary education Assam. Through the district elementary education officer Barpeta. Then thereafter the director, elementary education Heights. It later dated 14th of June 2019, has forwarded the same, Commissioner and Secretary to the Jobs of Assam, Department of
Irrigation.
Jobs of Assam, Education, Automated Village, Department is true. But the same also failed to evoke any response. In view of the submission of Mr. Abhay Garnet Council for the petition, it is provided that the proposed Garnet is nothing council for the response and offered it shall obtain up to their extract on in respect of the present setup of the letter dated 14th of June 2019. Place the matter after 1 week.
After 10 days.
My lord, date may be fixed. My lord, technically date may be fixed, lordship.
24th November.
Developed.
Item 10,
It is the lordship. My lord, by this petition, my lord, I have challenged the my lord order whereby deprovincialize the service of the petitioner, my lord. As because, my lord, it is the contravention regarding 311 of the 17 Act. And impugn order kindly see, my lord, page 76. Page 76. Initially provincialized in the year 2021, my lord, and subsequently it was deprovincialized. But at least this notice may be issued, my lord. Because subsequent clause, my lord, division bench of this honorable court reading down the state clause, my lord, 311 of 17 Act. And I have annexed the death judgment, my lord. Annexation 19, page 78. And operative portion, my lord, page number 123, page number 123, my lord. Paragraph 160 and 161. Having regard to the observation made in the above, we are the consider opinion that section 11 of the Act of 2017, the amended by the Act of 2018, can be saved only if the same read down by this honor to hold that just such central education institutions which were set up prior to 1/1/2006 of and which fulfill the eligibility criteria laid down in the Act of 2011 for provincialization of those institutions and the service of their teachers and employees and had genuinely submitted their application through proportional, seeking permission, concurrent recognitions from the competent authority prior to the cutoff date 1/1/2006. Their claims for provincialization cannot be extinguished merely on account of non-receipt of and or retrospective communication of the order of approval, concurrent recognition, permission from the competent authority. We accordingly read down the provision of section 311 of the 17 Act amended by the Amendment Act of 2018. So as to save the state of statutory provision from being declared unconstitutional.
Let notice go ahead.
My lord,
please,
my lord,
Refer file affidavit.
my lord.
Heard Mr. Patgiri learned for the petition. He does learn it something from.
I'm appearing for respondent number 1,
Part.
3, and 4.
Anybody for state of Assam?
Finance.
Opinion is there.
Hold on for the respondent of part 2.
তো
Oh, one,
আপুনি
respondent
PDF বিলাক
number
দিব
1.
না দাদা। PDF টো নিদিলে দিগদাৰ হৈ যায় মানে জলদি নহয়।
Hard copy, the petition of the article 26 of the Constitution of India, the petition of the sentence. The order dated 27/5/2025 by the Director Secretary. And also the order dated 3/3/2025 and the corrigendum dated 31st of August 2025. Also petition plus report and also verifying with order dated 3/3/2025, 27/5/2025 and the corrigendum dated 30/6. Let notice be issued to the response return within 4 weeks. However, no formal notice is required to be issued to the respondent number 3 and 4. Since they are represented by the records of the standing council. However, extra requested copy of the petition will be furnished to them during the state upon respondent number 1 and 5 be taken by registered post AD and also by the person from today is the matter of part 4 weeks.
Oblige.
Deeply obliged.
Itu belak nih. Mau cuma. This is for that I am another code look.
Have you seen the order? What is order for today?
So what's up? I need some time to instruction.
No, what was the direction of this court?
To pay the area salary.
Area salary. Then the area salary has been sanctioned now.
Yes. Area salary for the terminated period that has been sanctioned now.
What instruction is necessary?
Just that's it. 1 week time maybe even. Personal events is not required.
Or
Order.
Mr. Approve it or not for the page. And Mr. Katonia or that of the concept. Person to the order dated 24/10/2025. The content are remain present before the court person. And produce. One order. Dated 6/11/2027. Mr. Katonia learned counsel for the contempt of public threat. His sum of rupees 16,85,638. Being the area salary of the petitioner has already been sent. Mr. Gogoi learned counsel for the petitioner submits the activity granted some time to obtain credit. There is accordingly allowed personal appearance of the contempt or dispense with. This is the matter on. But the letters for this before the court today shall be tagged with the record by marking the same as annex or Y series.
Problem.
Well, in this case, my lord, on last occasion, Lottie was directed to place the appointment letter. my lord. On last occasion, Lottie was directed to place the appointment letter. Or else, my lord.
Yes,
Here, my lord, on last occasion, I have said there's a communication dated 22/10/2025, where it was, my lord, asked the district elementary education officer to provide the relevant documents. my lord. Accordingly, we have received, my lord. We have send it to the secretary to place before the joint committee, verify all the relevant documents. Thereafter, my lord, post will be created, my lord. May I place the communication, my lord?
when can we expect the result? Mr. Bora,
My lord. 3 weeks may be granted, my
3
lord.
weeks.
My lord.
heard Mr. Ghosh, learned counsel for the petitioner. And Mr. P.K. Bora, learned counsel for the contempt. Person to order dated 23rd of October 2025. The contemptor remains personally present today. Mr. Bora has produced one letter of the contemptor dated 7th of November 2025, addressed to the Secretary to the Doctor of some Department of School Education. And on the basis of the said letter, Mr. Bora submits that the information that has been called for from the District Elementary Education Officer Bawagao has been received. And the same has been forwarded to the Secretary to the Doctor of Assam for placing the same before the Joint Committee for verification. And the matter is expected to be completed within a period of 3 months.
My 3 weeks, my lord.
3 weeks. Accordingly, the matter stands adjourned for 3 weeks. This is release the matter on 5th December.
Because lordship, there is 2 orders, my lord is aware. One is a positive direction already passed by the court. Another direction will be passed by my court. Pass your lordship, that they should produce the appointment letter. My lord. Nothing has been done. Only they are saying that so my lord, within the outer limit of this 3 weeks, my lord, they should make the appointment. My lord. That's my humble submission, my lord. Otherwise, 3 months has already gone by. Court has directed to complete the entire exercise by 3 months. Now it is more than 1.5 years, my lord. It is
Would
there
be
in.
possible to produce the appointment letter?
Yes.
My lord, we are processing, my lord.
My land processing is going on for last 6, 7, 8 months. My lord. Nothing has been no outcome.
But this
Nothing.
appointment letter has to be issued by the secretary.
Whatever it is their matter. my lord.
We are processing, my lord. We
It
are
is their
processing. We are-
departmental matter, my lord. Why the petitioner to suffer for that?
Okay. But SSL raised the matter on 5th December. And on that day, the appointment letter of the petitioner
Yes.
is produced before the court.
Obliged, lord.
Personal appearance of the contemptor is dispensed with.
Obliged, lord.
Item 11.
May I please, your lordship?
Mr. Devi?
Lordship, here in this matter already, the petitioner's mother, she expired in the year 2018, your lordship, 2013. Then thereafter, the matter was placed on 3 occasions. It is good that the petitioner has not suppressed the, but the fact is that, your lordship, it is by OM dated 1615 and under that principle 10, that is, if the application is of remains pending and cannot be considered due to want of vacancies for a period of 2 years from the date of making such a will, require no further consideration and must be understood to have spent their force. And more so, since that 2013, the petitioner has is before this honorable court for the first time. So the harness and the immediacy is absence in the on the part of the petitioner. We can presume that this one, but
No, Mr. Devi, you tell me, going by the minutes of the district level committee, whether the ground for rejection is discernible.
in page 34, it has been said that not recommended due to want of adequate vacancy, perhaps. The word is not there. Then in page 27, it says that the relevant part is at page 28. It says the time elapsed. So that is what the OM says, your lordship, 1615. Then after that, before that, page 22. At page 22, it says that a want of vacancy, your lordship. And at page 18 also, due to want of vacancy. My submission is that if the urgency would have been there on the part of the petitioner, definitely should have been before this honorable court much earlier, your lordship. So now after 15 years, your lordship.
May I, my lord? My lord, both my parents were assistant teachers, my lord. My father died in 2006, my lord. At that time, I was minor. Thereafter, my lord, on 2013, my lord, my mother died, my lord, leaving me the only legal heir, my lord. I have no one to look after me, my lord. And I have immediately after the death of my mother, I have applied. The department, my lord, on 2014, I have applied, my lord. In 2015, my lord, my case was placed before DLC, and it was not considered as there was no vacancy, my lord. As per the DLC, I have annexed that my notes of the DLC, my lord. But there is no whisper in the DLC, in that particular DLC also, that there was no vacancy in that department. But my case, as it is a case of compassionate appointment, my lord, there is no whisper that my case was recommended for another department to appoint me, my lord. There was no such thing, my lord. And thereafter also, 4 occasions my case was placed, my lord. And always the department is saying, my lord, that there is no vacancy, my lord. Now my learned friend is submitting that I have no interest in the job, my lord. I am the only legal. How, my lord? I'll not be, because the department I am approaching regularly, my lord. They are saying that if there will be a vacancy, you will be placed, my lord. You will be appointed, my lord. Now my lord. Now they are saying, my lord, I have no interest, my lord. I have annexed all the my lord.
Both the
Can
parents.
you show any document that in other department
My lord,
there are vacancies?
my lord.
But, can you show me any document to show that there are vacancies in other department of that district?
That, my lord, I can take instruction, my lord. Now, my lord, I do not know. They will be knowing, my lord.
Lordship,
But this, no whisper in any of the DLCs that my case was recommended due to the non-availability of this department, because both my parents, I have applied in the service of my mother's post, my lord.
Lordship,
So-
taking by the, hold on.
So, my lord, can it be like, okay.
Going by the submission made by the petitioner, your lordship, since both the parents were working personnel service holder. So since the matter, the scheme relates to compassionate appointment, that is harness and the exigency and immediacy, your lordship. Now she is might be availing the pension for both. More so, she has, in the petitioner, she has, in petition column, post title column.
I'm not
This says
availing
that,
any pension, my lord. Might be submission, I don't know why
Then,
the department is
so,
taking.
she can avail the unmarried pension too, since she has not been married till the end.
My lord,
So,
I have applied for the post of my mother.
no, whatever we saw,
Point
when her
points.
application will be considered, the financial comparison will be made, your lordship. Now, it is her submission, both her parents were working for service holder. Now, again, she can, by going to a post title, it seems that she is eligible for the unmarried pension, your lordship. So where come this schemes made? That will be many other more eligible persons and desirable persons are here, candidates are here.
But
And
they-
more so, what I am submitting, your lordship, matter relates to 2013. Now, we are not denying, it is not, if urgency would have been on part of her, your lordship, she could have been before this honorable court before.
So they will let her apply next.
My lord, I am not taking any, I have not availed any pension, my lord. At the time of my father's death, my mother was alive, my lord. And this compassionate appointment, my lord, I am seeking against the post of my mother, my lord. And my lord, where is, my lord, if I am not qualified, the DLC doesn't say so, that I am not qualified. And it is a compassionate appointment. There is no question of qualification, my lord.
What I intend to submit, your lordship, that she is eligible for. She can avail that. That's what I'm intending to submit before this.
Let her obtain inspection regarding the availability of vacancy.
Vacancy, your lordship, to that extent, already the matter has been placed 4 times, your lordship. The scheme says very clear it is that if in 2 years it doesn't meet so, then it will presume to be have spent the force, your lordship.
But in any other department, my case was not tried, my lord. But simply saying, my lord, that there is no vacancy, and now saying after so many years, so many DLCs, my name came, my lord, and want a vacancy, in every DLC, my lord. Now he is saying,
That
not-
is what if hunger would have been on her part, should have been before this honorable court, your lord. It is not that she.
I am
is,
before this honorable
monetary
court, my
constraint
lord.
right
I
now,
have
because
it by,
both her parents were service holders, your lordship. Now she can avail that pension on unmarried ground, your lordship.
my lord, this case is not about
Different
pension.
No, that is a different aspect. So Terry, can you tell me?
No,
why?
What I feel, your lordship, there are many cases where both the parents had died out of cancer, 4th grade. But those persons are not being, so getting the matter at hand, I'm bound to submit this here. That's why I have said. Whatever we saw, if your lordship, since your lordship has instructed, I'll obtain the try to.
You tell me why her case was not considered in other department?
That. Even the annexer that has been annexed, not recorded want of adequate vacancy. So it doesn't speak that only her case was considered in that particular department. No. It might have been so after taking into consideration the entire department.
Minutes of the meeting is not speaking about the availability or non-availability of the vacancy in other department.
No, my lord, only want a vacancy.
Lordship,
in every
by lordship on
vacancy.
perusal of page 34, your lordship.
Hmm.
On perusal of page 34.
Yes.
Not recommended. want of adequate, the other words are not there, Your Lordship. It is not said also that not recommend due to want of adequate vacancy in that particular department only, Your Lordship.
Better you do one thing, you obtain inspection from the DLC as to whether her case was considered in respect of other department.
My lord.
Or is SSDA learned counsel for the petitioner, Mr. Terry learned standing counsel for the respondent. Respondent number 3. Respondent number 3 and Mr. Kokon for respondent number 1, 2, 4, and 5. 1, 2, 4, and 5. 6.
I am for 3, Your Lord.
And my lord, 6 also 6. Actually, my lord, there's a typographical error. It should be 5 actually. Wrongly written as 6.
Oh,
After 4, it is given 6. It should be 5.
it should be 5,
4 and
yes.
5.
The petitioner is aggrieved for non-consideration of her name by the district level committee of which district?
Nagaon district, my lord.
Nagaon district. For being appointed on compassionate ground. Is there learned counsel for the petitioner referring to the annexures? Annexer number, what annexer number?
Annexure 2, my lord, 2, 3,
Annexer 2, 3,
4, my lord.
2, 3, and 4. Some extent. The case of the petitioner was placed before the DLC on 3 occasions. And all the occasions the same was not considered for want of vacancy. Ms. Priya further suggested the findings of the making of the DLC is silent as to whether the case of the petitioner was considered in respect of other department, vacancies in respect of other department. And in that view of the matter, it is provided that Mr. Devi learned standing counsel for the respondent number 3 shall obtain necessary instruction whether the name of the petitioner was considered by the DLC in respect of the vacancies in other department of the same district. This is the matter on this. First of December.
Sorry, then we do.
My lord. Instead of 3, it would be 4, my lord. 4 times. It was placed 4
The
times.
last one, dated
17, my lord.
7.
2017, my lord. Oblique.
No, fairness of much.
Happy with your lordship. My lord, this is my lord matter where petitioner is an aspiring candidate of NET, my lord, UG, my lord. And my lord, he is a candidate opting for admission in MBBS PTS course,
In
my lord.
which category you have applied for?
I have applied for my lord in the category of my lord OPC NCL, my lord.
OBC?
NCL, my lord.
NCL.
I belongs from Coach Rajpongsi, my lord.
No, applied under general category.
Yes, my lord.
Applied under general category.
Let me complete.
Okay.
Initially, my lord, problem is initially, my lord, at the time of application, my lord, while submitting my application, my lord, I was not having the certificate. Though I help from that community, my lord, but later on, subsequently, my lord, since I have not submitted my those documents, required documents, my lord, therefore I was treated as general category. Therefore, I have submitted an application saying that since I'm not having the application, the documents which I belong to OBC, my lord, subsequently after obtaining, I will submit. So kindly consider me as a category of OBC. That is, I have submitted an application. Later on, after obtaining the certificate from the concerned authority, my lord, the district Commissioner, my lord, Kamrup, my lord. I have submitted. Now, but unfortunately, my lord, I could not be considered in that category, my lord. So, my lord, probably I must miss my pass, my lord, if, my lord, academic, my lord, that 1 year I may be lost, my lord. So in the events, my lord, if there is any vacant post, my lord, vacant seat, my lord, well, let him take instruction whether I can be accommodated, my lord. Otherwise, my lord, I will be as I
When
submitted.
you have filed the application.
My lord, my
you
application
consider
will,
your case as OBC MCL.
yes, my lord, may kindly come to annexure, my lord. Annexure 11, my lord, page 63.
And whether it is within the date fixed by the director, Mr. Bora?
No, my lord.
Then subsequently, my lord, it has been followed by page 76.
Wait for some time.
Yes, my lord.
Mr. Bora,
Yes, my lord.
the Director of Medical Education has issued one notification
Yes, my lord.
inviting application from the other category candidate, reserved category candidate. What was the date?
That is at page 65, sir. Page 65, annexure 12, my lord.
55.
65.
Right.
Annexure 12, my lord.
And he filed the application before date of issuance of notice. Page number 11, you see, date is 11/7/2025. And the date of notice is 15 July 2025. Then why his case has not?
But my lord, whether it has been received or not, I don't know, my lord, because it doesn't indicate that it has been duly received at the office. Only the application that has been filed recently, my lord, at page 22, it shows that it has been received at the office of the Director of Medical Education.
Page number?
At page 80.
80.
Type copy at page 79, my lord.
Hmm.
Original page 80. But this page 63 application, whether it has been filed or received, it doesn't indicate, my lord. So whether, my lord, this page 63, it has been received or not, my lord, I have to obtain instruction, my lord. Because this application doesn't show that it has been duly received.
Received by the author.
Yes, my lord.
Page 76, may also log. Page 76, my lord. 76, my lord. That is the date when I have submitted, my lord. The certificate, my lord. Now lordship may come to para 11, my lord. Page 21. Last two line, my lord.
Hmm. Hmm. Which lines?
My lord. Para 11, my lord. Page 21.
Mr. Bora, you obtain instruction.
Yes, my lord, I will obtain such.
If, my lord, whether I can be accommodated, my lord, in any other, because my lord, unfortunately, my lord, this petition, though we file on, my lord, 24/10, my lord. This matter could not be listed, result has been out, my lord, on 6. Third round of result has been out also.
Third round admission completed, my lord.
6 November. 6 November, my lord.
So final admission also completed, my lord.
Is there any vacancy?
If any stray vacancy is there, then probably there will be a stray round, my lord. Probably 2, 3 or 4 seats may be available. And if available, my lord, then the stray round will be done, my lord. Because after third round of counseling, this was the final round of counseling, my lord.
Third round.
Third round. So that is completed, admission process is also completed. So if anybody doesn't take admission, then a stray round will be held, my lord.
Provided I come within the consideration. Provided.
So in the meantime, let me obtain instruction, my lord.
Or Mr. N.K. Modi, learned engineering professional, PT boss. Petition under Article 226 of the Constitution of India, the petitioner has right for his direct to the minister as contact number. More particularly, to the response number 3 and 4 that considered the application of the representation 6, 10, 2025, 13, 10, 2025, submitted by the petitioner. In the category of OBC and CL, the
Next
extent of the petitioner is found to be on merit for admission. In the course of PDS,
Yes, PDS, my lord.
in the government medical and dental colleges of Assam.
All BDS.
PDS, fine. Mr. Modi, learned counsel for the petitioner, some extent. The petitioner has appeared at the national eligibility term and then test. Certificate need undergraduate course 2025 and her serial number was 251153. Mr. Mori further some extent due to one of OBC NCL certificate, the petitioner has applied in the general category. And thereafter, the petitioner has filed 3 applications. Drug representation dated 11/7/2025, March 6/10/2025, and 13/10/2025 for Saint Robert category from general to OBC, NCL to. But the case of the petitioner has not been considered by the respondent of court. That being active, the petitioner approached this court by filing the present petition. At this instance, Sabora summits that may be granted time to obtain inspection as to whether there remains any vacancy as the final round of counseling has already been completed and the admission process has also been completed. As to whether the application filed by the petitioner on 11/7/2025, 6/10/2025, and 13/10/2025 have been received by the respondent authorities in time order. Accordingly, it is provided that this is a list of matter after 1 week or sorted.
Next week, my lord, anytime.
Next week, my lord.
Monday?
Yes, my lord.
On 17th,
My lord, just if I may, my lord. In the meantime, my lord, in the events, my lord, if there is any other left out post, my lord, vacancy, that may not be, my lord, filled up.
That regard also, he will obtain his.
Yes, my lord, because it has not been notified yet, my lord.
My lord, in the events, if
No,
there
my
is,
lord,
if
it
there
not
is, my
necessary,
lord,
at this stage.
if there is, my lord, otherwise, this petition will become infructuous, my lord.
By next date, my lord, even if stay vacancy occurs, my lord, so it will not be completed
they-
by the next date, because it has to be notified. So that prayer may be considered on the next date, on the basis of the instruction.
Observation, my lord, if
Obliged,
any-
my lord.
otherwise. Any other observation, my lord, otherwise petition will become infructuous, my lord.
Not necessary.
Oblige, my lord.
Item 13.
My lord, the issue of the facts is similar to item number 8.
Maybe.
Okay, we'll take up all the matters together. And 38 also. After some time.
Item 38 is also. The item for order is vacating. Item number 39.
Before my learned senior friend starts, my learned friend has filed an application under Article 2263 for vacation of the interim order, my lord. I have received the copy on 3rd, my lord. And it's a very big petition and numerous allegations have been made, my lord. And my client is 76 years old. I need his instructions. I need to file an objection, my lord, to put it on record. Because there have been allegations made against me that I'm a member of a political party and other allegations are also there. I have to put it on record, my lord. So I kindly pray, my lord, sometime maybe,
Answering to all those allegations are necessary.
not necessary according to me, but let my learned friends.
Please come to page 37. A of my
IA?
I 3569. Page 37.
Yes.
So before I start, Lordship will take note of the date. The order is dated 22/8/25. My lord, I will not take the name of this person because all this person, Lordship, the petitioner, respondent number 6 now, who have taken, all of them are renowned academics, Lordship. So being a university student, Lordship, I have to take name of all these people. It is not good, Lordship. So I am in profession, Lordship, I have to file this application because for the interest of the institution and for the interest of the student, my lord, what is going on, Lordship will see. Lordship, this is an order dated 22/8/25.
Mr. Sharma, since you want to file objection.
No. Yes, Lordship, let him file. What I want to show, Lordship, this 22/8/25.
No, let him file objection. We'll give a final consideration on the next day.
Yes, on the Lordship will dispose of the whole writ petition on the admission stage, Lordship. Today, Lordship, what I want to do, Lordship, will take note of one thing only, Lordship. This is order dated 22/8/25. Case 37, Lordship. For a moment, Lordship. Lordship, because this is educational institution, Lordship, they are suffering. That is why I am saying, Lordship. Lordship, may please come to page 38. This court, considering the submission made by the learned counsel, find it appropriate that the impugned order dated 26/25 be stayed till the next date of hearing. So, this order is passed on 22/8/25. Lordship, directly come to page 134.
130?
Oh.
Yes.
That is that, Lordship, in top governing body meeting, the date, Lordship, will take note. Page 134. On the top, Lordship, after the governing body meeting, Lordship, date 28/25. Now, Lordship, resolution number 1.
Hmm.
The new chairperson of JB, so and so, takes charge of the new post of chairman in the so and so direction, that so and so, and higher education, dated so and so. Which order was paid by on 22/8. Before that, Lordship, this person, he has taken charge on 1st of August. He convened the meeting on 28/25, and he took all these decisions, Lordship. And he is sitting for last 6 months, not a single meeting. And Lordship, this college is suffering. No NAC, nothing. The college will be closed, Lordship, in some day. Lordship, please come to my page 26. I have said what I am suffering, Lordship, for this interim order and continuing like this. This person was continuing as a managing committee chairman for last 3 terms. What right here, Lordship? I am sitting here in this court in item number 8. Lordship has asked the question, what legal right you have as an headmaster to file this writ petition? The same question I am asking, Lordship. What legal right this person have, Lordship, to file the writ petition? As a nominated member, Lordship, of a governing body. And he is continuing for last 3 terms. And the Lordship, please come to page 26. What I am suffering, what the court is, this college is suffering. Para 29. Lordship, promotion of teaching and non-teaching staff halt. Interview for vacant teaching and non-teaching staff post halt. Everything, Lordship, since the interim order. Last 3 terms he is continuing as a chairman. Taking an interim order from the court, he is sitting. All right, he takes his interim order from the court. Why he has not asked for a governing body meeting? If he continue, what prevented him? Why he have not taken all these decisions, Lordship? Why he wants to close this college, Lordship? That's my problem. Because he is a political man, man.
Well, at least for the first time, I have come to know of the allegations.
Well, that is the whole problem. I have given everything, Lordship, because after the Assam Gana Parishad, he has now established a new regional political party and he is the head. And he has started the political party and he wants to close this college, Lordship.
I'll make a statement on oath, my lords, that I'm not a member of any political party.
Yes, Lordship, I have given the all document, Lordship. It's a matter of record. I have given in this petition, Lordship.
I'm very thankful
I have
to
given
the
all these documents.
college, my lords, at least for the first time, they have come out with the reasons why I'm removed unilaterally, my lords, without there being any opportunity, my lords.
Record to be...
And for 3 times, my lord, I've been
reason to be
appointed.
Recorded, Lordship. Reason
Kindly.
not to be supplied to
And my
him.
lords, who is the college, my lords?
Person, Lordship,
The appointing,
what-
the
what
nominating
right he has,
authority is the
Lordship, to
state.
continue for 3 terms.
Mr. Mohanto,
My lords,
we'll kick the matter on Thursday.
my lords,
In
there's
the meantime, you file your objection.
one difficulty, kindly, my lords, my lord. My lord, I have already filed my leave application from 14 to 21. 7 days I'm not there, my lord. I'll be out of station, my lord. Can it be after that, sir? Request for final decision. I'll file my. Because it's a mammoth petition, my lord. Number of allegations. my-
Any time convenient to him, Lordship.
I'm very grateful.
Also, he has some problem, 21 to year. Anytime, Lordship, in the interest of the college,
Yes.
I said, let it be on 26, Lordship. It is for the
26, 26.
students and the college. I thought, Lordship, after filing this application, you will withdraw the writ petition. He is such a person, he is such a renowned person. I tell my junior that, see, once you file this application, he will withdraw the writ petition. He will not continue. 3 term, Lordship, continuing as a governing body chairman. What right he have, Lordship? From 1998, Lordship.
The petitioner did not take any application,
Person
my lord.
wanted, and education is, Lordship, this is a business. Lordship, to be
Yes.
a president of a college.
And he was appointed by the government, my lords. And the government
Okay,
is not for your lordship, my lord.
now government
He
has
is
sacked him.
nominated by the government.
Now government has sacked him.
In
Why
fact-
you want to continue?
In fact, the college does not have any
What
right
right
to
he
say
have?
my nomination, my lord. Who's the college? The nominating authority is the government of Assam. The government is not before your lordships. I'll take instructions from my client, my lord.
Lordship will
Like
just,
my learned
Lordship
friend.
will- Lordship will just
Significant.
call for the record because all reasons are recorded. His whole dossier is there in the record.
Please
The
request
education
Lordship to
minister has written everything.
Behind
What
my
my
back.
learned, what, yes, behind your, because what you are doing, government is bound to do behind you. And government has to reason to be recorded. Reason is not to be supplied to you.
Who is appearing for Demoria College?
My senior friend is appearing.
No, who will produce the record? You have. to produce.
No, I'm not, but the government will put this, government, it is the decision
Well,
of the
only
government.
next date, my lord, would decide if it is relevant. I don't think the records are relevant, college records. It's already there, my lord, in the application.
Why records are not?
Lordship may call for it. Call for
See
it.
the record.
Call for it.
Who is he?
Yes.
Lordship can see from the record, who is he?
And they may also file the affidavit, my lord. In the meantime, the government of Assam.
No,
The
the notice was issued in the main rate petition.
Unnecessary, Lordship, all, everything is there.
in the IA, notice has not been issued. Lordship may issue notice in the IA. Give me some time to file my objection.
Or Mr. S. Sharma, learned senior counsel, assistant prime minister, learned counsel for the taken. And Mr. Mohanto for the respondent of the party. This application under Article 226 within the Constitution of India. The petitioner has applied for vacation of the interim order dated 22/8/2025 passed by this court in the number 4879 of the. Mr. Mohanto, learned counsel for the opposite party, submits that he may be granted some time to file objection in this application. And in the meantime, notice may also be issued. Notice may also. Mr. S. Sharma, learned counsel for the applicant, however, submits that the respondent number 3, the Director of Higher Education may be directed to produce the file, concerned file before this court on next date. Accordingly, we are taking note of the submission of learned counsel for both the parties. It is provided that notice be issued to the respondents returnable on
6 law.
26.
An endeavor be made, Lordship, for the interest of the institution, Lord, to dispose of Lordship. Otherwise, on that day, you will say, I will file a reply, I will file a so and so, all this will go on, Lord.
No, whether all
At least the miscase.
For respondent number 6, I am appeal. Okay, Mr. Your name? TK Bhuya for respondent number 6. Okay, good. And Mr. Bhuya for respondent number 1 and? 1, 2, and 3. No, in IA. 1.
1 is the petitioner. IA, 1 is the petitioner.
No, respondent.
Res-
In this IA, State of Assam, who is representing?
Opposite party number 1.
Respondent number 1 is his client.
The opposite party number 1. in the IA.
Opposite party number 1. In the IA. Raised Lordship government is 2, 3, and 4. And my learned friend is appearing for respondent number 6. And 5 is UGC laws. UGC has standing counsel. Yes, he is there. My learned friend is there for UGC. So all are here. If there is no notice to be sent, we will just exchange our.
All the respondents are represented, on the opposite parties are represented by their engaged counsel. Standing counsel, no formal notice is required to be issued, however, extra requisite copy of the parties to that. This is the matter on 26. In the meantime, Mr. Onto shall file.
Yes.
his
If the
objection.
other parties also wish, they can also file their pleading. If the government wishes to file their government of Assam also.
The other respondents are also at liberty to file their response. Mr. Bhuyan, learned standing counsel for the respondent number 2, 3, and 4. Shall produce the relevant file before the court on next.
Deeply.
an endeavor be made to dispose of this miscase at least, Lordship, and the otherwise,
Miscase.
Lordship, there is no point.
No
of
problem,
soliciting
no
it.
problem.
Okay, on that day, an endeavor will be made to finally hear and dispose of the petition.
And in the main case, my lords, the interim has to be continued in the main case.
Interim order passed in the WPC numbers.
I'm very grateful, my lord.
Till the next date, Lordship. In
Till
till
the-
continued till 26th, till the next.
Till returnable day.
Five promotions.
My lord, this honorable court has on earlier occasion has directed to pass speaking order regarding his views. And speaking order has been passed, my lord, on 4/11. This is the copy, my lord.
Furnish a copy to him also.
My lord. Main has to it. Yes. No, to more capacity. Okay, copy to window.
So Sharma, you need time to obtain instruction.
My lord, I want to file a reply to this. If my senior friend could kindly bring it on record through an affidavit, it would be useful, my lord. I want to file a counter to this. Because my lord, I have just got it, but from a perusal of the same, it is saying that I am not entitled, my lord, last para. So my lord, I am entitled to those benefits, my lord. So if my learned senior friend could kindly bring it on record, it will be
My
useful.
lord, it may be kept as a part of the record, my lord. So, my lord, unnecessary, my lord, another affidavit, my lord, only for that purpose.
My lord, for if it is placed on record, I cannot file a counter to it. I want to file a counter to it. That can only be done when it is filed on affidavit, my lord. I want to file a reply to this, my lord.
I don't have any problem, my lord. If it is so required, my lord, I will file it.
Heard Mr. P.R. Sharma, learned counsel for the and Mr. P.J. Popon, learned Islamic counsel for the Guwahati University. Mr. Popon has produced with the speaking order dated 4/11/2025. And submits that the direction issued by this court dated 10/1/2024, passed at WPC number 4590 of 2021 has been applied. So Sharma submits that there is a requirement for printing of record the same speaking order by filing an affidavit, so that he may file his response to the same. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that Mr. Popon shall file one additional affidavit pending on record. You have filed your affidavit earlier? No.
No.
So Popon shall file an affidavit pending on record, said speaking order dated 4/11/2025. Is the matter after 1 week?
I'm deeply obliged.
Most of it.
Pending items 8, 13, and 38.
May I please, Your Worship? My lord, the school of the petitioner, my lord, petitioner is the president of the SMDC of the school. And his school is conducting the HSLC examination for last 36 years. This time, my lord, his school has been dropped. Firstly, my lord, it was on the ground of that the boundary wall was not constructed. And that's why, my lord, it was dropped. And in this regard, my lord, the communication dated, my lord, 25th September, and except 3 of my case has been.
My lord, I have submitted the relevant portion of the regulation only, my lord, regarding examination, conducting examination. My lord, at my lord, before the last page, my lord. 14, examination centers. These are the requirement, my lord. And board has the power to pick the, my lord, center for examination. And board has been conducting the HLC examination. And they have the every right to pick the center for examination.
That we are not disputing, my lord, that board has no right, that we are not disputing. Yes, that we are not disputing, my lord. The regulation, what they have, the regulations provided, on the basis of that, they have issued the circular. And as per the circular, my lord, the school has the, my lord, the center must have minimum 250 students. And in my case, my item number 13, WPC 6336, 6336. Your lordship will find at page number 26.
Yes.
This is the impugn, my lord, whereby they have stated that a school is not fully covered by boundary wall. I'm reading from the, my lord, last one. School is not fully covered by boundary wall. That's why, my lord, they have rejected my this time. And your lordship will find that Annexure 4, I have, the school has immediately, having come to know about this letter, my lord, immediately they have constructed the boundary wall. It is, your lordship will find the photographs. It is given at page number 28, 29, and 30. School, they have, the committee has constructed boundary wall overnight, my lord. To remove that defects and to fulfill the requirements of the mandates.
But who are the petitioners?
Petitioner is the, my lord, SMDC president, my lord.
SMDC president.
Yes, yes. Thereafter, what happened, my lord? After that, my lord, they have issued another letter, Annexure 5, my lord, page 31. They, in order to intentionally avoid us, my lord, what they have written in the last paragraph, you also will find at.
Sir, Professor, you tell me, is it not the discretion of the authority where they will?
Yes, yes, of course, but the discretionary power, they have to use, my lord, rationally. They have the discretion because.
First, you have to establish what legal right you have in conducting the examination.
A question of legal right, my lord, will come, my lord, because the school is in the center point and feeder schools are there. And the students, my lord, who are, my lord, will appear in the examination center.
You see, the students are not the party in this proceeding.
Students are not the party in the proceeding. SMBC president, who is also the representative of the students also, my lord, from the school. Because SMDC president is selected and elected, my lord, nominated, my lord, after getting the consent from all the concerned authorities and the local people.
You know, which part of your petition you have mentioned that you were representing the students also?
I have stated, my lord, he is the president of the.
Where is the averment in your pleading?
Paragraph 3, my lord.
No, that you were representing the students of the said school.
President himself can represent, my lord, the matters, issues related to the school, my lord. Because he is appointed, my lord, by following the consent and the confidence of all community, all categories of people, my lord, all sections of people, students, guardians, local peoples, and the government officials. You'll also will find at page number 23, my lord, my school at serial number 29. In our school, my lord, number of students are 156. And the center where they have given, only they have got 61 students. The center is given in the name of Bagurihati HS School, serial number 180. They have got the only 61 students. And our school at serial number 179 is getting, my lord, 156 students. 156 students.
Then what is the distance between the two?
14 kilometer, my lord, from the remotest student's house to the school, my lord, 14 kilometer.
14?
14 kilometer. The
No, from the earlier center,
earlier center is around, my lord, 6 to 7 kilometer.
6 to 7.
7 kilometer.
And
The-
Sir Roy, what is the distance? My lord, right now I have no, my lord, instruction regarding the distance, my lord. And my lord, 15th after 1 week, my lord, I will obtain the complete instructions regarding these matters. my lord. All the matters. There's 3 matters. Can you obtain by Friday? Next Friday, my lord.
Yes, sir.
This Friday or next?
This Friday, this Friday.
My lord, next week, my lord, or Monday or Tuesday? Monday. Monday, let it be on Monday, Mr. Coletta.
My case, my lord, the guardian of the petitioner also, guardian of students also representing, my lord. And in my case, my lord, no, my lord, communication was served upon the petitioner school, because what is the ground of cancellation, why it was cancelled? And it is shifted to a center, my lord, where earlier there was allegation of malpractice. So, my lord, earlier center was withdrawn from that school. And Lordship will fix it for
Friday.
yeah, Friday may not be possible, but some other matters are fixed.
Next week,
my lord. Monday then, my lord, next Monday.
Monday, he will obtain inspection in respect of all the, how many petitions are there?
3, my lord.
In respect of all the 3 petitions, he will obtain inspection.
My lord.
My lord, item number 30th, I have not received the copy, my lord.
Copy, my lord, in fact, 2 copies was served, my lord, but still I am furnishing, but 2 copies was served earlier.
Furnish one today?
Yes, my lord.
Yes, my lord, I received.
I have furnished it.
Item number 38.
Appointed.
My lord, chairman and convener of district level committee, DLC come inspector of schools. My lord, no, these are two separate
different.
institutions, my lord. Inspector of school is different, and my lord, the chairman and convener of DLC is different. So my lord, inspector of school may be separated or it may be included.
My lord, in the last occasion also, they have raised this issue, Lordship. I have pointed out page number 32, my lord. Lordship, kindly have a look at that page number 32. It is the one and same person. And first let them obtain the instruction, my lord.
You are in item number
38, my lord. Page number 38, my lord. 32, my lord. This is the last page of that provisional select list where my the petitioner school name was appeared, and you kindly see the signatories below, my lord. Inspector of school comes chairman and convener. He is the one and same person, my lord.
And here are
Your
two
document is
signatures.
saying, I am
Here
not saying.
indicating two signatures. One is the
One-
short one and another is the below.
The principal.
And principal is another one, it's left side.
Principal, that is the
Actually,
co-chairman.
Usually, it is the signature of the clerk who put up the matter.
Yes. So let them first obtain the instruction, my lord. Yes.
And regarding my lord, commissioner and secretary, it is only secretary, my lord, not commissioner. Nowadays, commissioner is not there, my lord, only secretary.
Okay, you.
Just taking that point from the last occasion also.
Next. Third, Mr. Officer, learned counsel for the petitioner, T.K. Roy, learned counsel for the secretary education, learned counsel for respondent number. You are for respondent number, Mr. Roy? My lord, I am for ASF, my lord, ASFEB. In all the case.
General clauses specified public as a commissioner in
Assam State Education Board. Respondent number 2. And Mr. Yu Sharma for respondent number.
Item number
38.
38, yes. Respondent number 1, 3, 1 and 3.
1 and 3. Anybody for the district commissioner? Nalbari? Mr. Roy, Learned Council for the respondent number 3 submits that he may be granted some time to obtain up-to-date inspection. There is a law, this is a list the matter on next month.
17 November.
Same order in other methods.
In item number 13, my lord, same order.
Item number 8 as well. Much.
Items for admission. Item number 14. Chartered matter.
May I please your lordship? My lord, the lordship permits, I'll take only 1 minute as a gist of the case, my lord. The petitioner was appointed in the year 89, and then suddenly in the year 2012, salary was stopped, and thereby this petitioner came before this honorable court. In the meantime, the government of Assam took the initiation that from 91 to 2001, the teachers who were appointed irregularly, for them there will be a screening test all over the Assam. In respect of that, my lord, 2 advertisements were issued calling all the teachers, those who were appointed during that period and their salary was stopped, to file their testimonials for necessary verification district-wise. So when I filed the writ petition, my lord, that was in the 2016, a first affidavit was filed by the respondent number 1. If your lordship only looks at 1 paragraph, my lord, then I'll come to the next. That is in page 50, my lord.
Yes.
It is the page 49, paragraph 17 starts. My lord, page 50, the subpara above paragraph 18. My lord got it, my lord. The deponent states that the government would now prepare a cabinet memorandum incorporating the aforesaid parameters, and the same would be placed before the cabinet for approval, which is under process. So that was the stand of the government, my lord, because at that point of time, the advertisements were already issued from all the irregular teachers for that screening, my lord. So that was completed, my lord, in the year 2020. Now, my lord, I'll directly come to their affidavit, my lord, which starts from page 68.
This is the affidavit filed by this page number 50.
That was by the
Respondent number 1.
respondent number 1. Respondent number 1 sought time from this honorable court that they are going to do the needful according to the cabinet decision. That was the thing, my lord. That permission was taken from the court to allow them sometimes.
Thereafter,
my lord, would your lordship be pleased to, my lord, before I proceed, my lord, only 3-4 dates, my lord. Those will be necessary, my lord. My lord, my appointment is 19/12/1989. Could it be just noted down, my lord?
it is not there in your petition.
It is there in my petition.
Where you have mentioned it. 1912, 1989.
Yes, my lord. My lord got it. My lord, 7/6/1995, my service was regularized. That is annexure 3, page 21.
Yes.
My lord, the petitioner was transferred to from Damaji to Dibrugarh by the order dated 5/2/2001, my lord, that is annexure 5, page 26.
5/2.
5/2/2001, 2001. My lord, then petitioner completed junior basic training by certificate dated 26/8/2011.
20.
26 August 2011. That is annexure 9, page 33.
Twenty-six, 8, 2000.
2011.
Page number.
Page number, my lord, annexure 9, page 33. Next, my lord, my GPF account was opened in March 2012. That is annexure 10, page 34.
Annexure 12.
Annexure 12, my lord. Annexure 10, page 34.
Okay.
Next, my lord, this is the impugned order, my lord, in the writ petition 6/2/2012, whereby my salary was stopped.
Yes.
Impugned, my lord. My lord, one important document is there, annexure 14, page 38, that is 8/11/2013.
Annexure.
Annexure 14,
Page number.
38.
The communication dated 8/11/2013.
Yes, my lord. My lord, 8/11/13, my lord, only one thing your lordship may mention, my lord. There it was mentioned that I received salary. That is important for the case. I received salary that was by director informing the commissioner. That letter, my lord, 8/11/13, that is page 38. Would your lordship be pleased to see once, my lord?
Which is the relevant paragraph?
My lord, relevant paragraph is second para, my lord. Thereafter, she had been transferred from so-and-so school, Damaji, to Notun Amalapatti, so-and-so, Dibrugarh, as per order issued by the DE Assam, by memo number so-and-so, dated 5/2/2001. That is already there.
your lordship has already noted down. And also she has been getting salary, her monthly salary up to January 2012. That is quite crucial for this case, my lord. January 2012. My lord got it, my lord.
Yes.
Now, my lord, now I'll directly come to this affidavit filed by the respondent number 2 that starts from page 68, my lord.
Yes. Additionally.
This is additional affidavit. Affidavit in opposition, it says. My lord, I'd like to bring your lordship's attention to page 78. That is the cabinet memorandum, my lord.
70?
78.
Yes.
My lord, when this, as I have already submitted, my lord, after the screening, they made 3 lists. That is page number 80. List 1, list 2, list 3. My lord, may I come to page 80, my lord?
Yes.
My lord, list 1. This is the 3rd line, I think, from the top. My lord got it, my lord.
Yes.
The teachers who have received salaries at some point of time and having JBT, DLED are included in the list 1. So I am for the list 1, my lord. List 2 is regarding the persons do not have the JBT, but they were receiving some salary. And list 3 is the persons who did not receive salary nor qualified. So I am for list 1. My lord got it.
Yes, but how this cabinet memorandum will cover your case?
I'll-
Since here.
I'm coming, my lord. Now, immediately after the list 3, now the education department has been proposed that. My lord got it.
Hmm.
The first one, my lord.
Hmm.
Approval sought for accommodating those teachers who have received salary up to 2007. When they did the screening, they formed this slot. The up to 2007, the person who received salary, they are going to be accommodated. And my lord, as your lordship is just noted down, I have received salary till January 2012.
Hmm.
So as far as the salary is concerned, I am covered. Approval sought for accommodation those teachers who have received salary up to 2007 and have successfully completed junior basic training oblique DLED. I completed junior basic training by creating personal oblique supernumerary post with prospective effect from the date of approval of the cabinet. So I am in, now the education department has been proposed to that I am serial number 1. I am covered by serial number 1. Would your lordship be pleased to mark it, my lord? Now, my lord, the views of the different departments like judicial department, that is page 81. My lord got it. Page 81, my lord.
Yes.
My lord, in the nutshell, I'm saying, my lord, 1, 2, 3, 4, 5, 6. My lord, 7th line, would your lordship be pleased to get the however the High Court?
Yes.
However, the High Court approved the decision of the state government not to terminate such employees working since last more than 10 years, not in sanction post, till their normal retirement, and to enlist such employees in health and accidental death insurance scheme, and directed the government to implement the said measures. So this was decided in view of this Honorable Court's order and the Supreme Court's order, my lord. That is the view of the judicial department. Now, my lord, next is the view of the learned advocate general. My lord, the views of the learned advocate general Assam. I have gone through the records and the proposed policy documents in the file. The issue is that arisen for my opinion in the instant matter is as to whether ex-cadre appointment and regularization of services is permissible in law by way of policy decision. After going through the catena of decisions, and most important one thing, the decision rendered by the Honorable Supreme Court in Manohar Lal Sharma versus Union of India and another 2013 so and so, I am of the considered opinion that the policy decision that the government is proposing to take is permissible in law. Now, my lord, comes the view of the finance department. My lord, I'll come to directly serial number 1, last line. My got it. My lord got it. The person who have received salary up to 2007 and having junior basic training department are 1578. However, it is clear that they were initially not appointed as per rule. As such, finance department is of the view they should be given at par with regular pay scale with the prospective effect because they have professional qualification. That is junior basic training. Now, my lord, the last, the cabinet approval sought. Number 1, I'm with the number 1, my lord.
Yes.
Approval sought for accommodating those teachers who have received salary up to 2007 and have successfully completed the junior basic training /DLED course by creating personnel supernumerary posts with prospective effect from the date of approval of the cabinet. Those posts will cease to exist as and when the incumbent retires from service. Now, my lord, would your lordship be pleased to come to the annexure 1 of the affidavit, that is page 76.
Yes.
This is after the cabinet decision, my lord. Dated 24/7/2023. Issued by the Joint Secretary to the Government of Assam Department of School Education. My lord, after paragraph 2, after finishing of the paragraph 2, before the list 1 comes, the committee prepared 3 lists based on screening committee reports. My lord got it, my lord. I am for the list 1. The teachers who have received salary up to 2007 and onward and having JBT DLED are included in the list 1.
Whether your name was there in the list?
No. That is there. Last paragraph, the page 77. Her case was then brought under the ambit of the irregular category of teachers, and the case was screened on 19/4/2014 by the scrutiny committee as per instruction of divisional commissioner UAD, but her name was not approved by the screening committee as she did not meet the criteria laid down by the cabinet memorandum, and hence she was not offered accommodation. Absolutely contrary to the cabinet memorandum as well as the decisions taken by them. It is evident from that annexure. Now, would your lordship be pleased to take my reply, my lord?
Page number.
My lord, page 55. I don't know whether it will tally or not. I'm sorry, my lord, but it starts,
Page number 52.
starts from 52. Your lordship got it, my lord. My lord, your lordship may come to page 55, point F. That it is also stated in the affidavit that the government has been in consideration of the case of the petitioner or other similarly situated persons and decided to resolve the issue subject to fulfillment of the criteria conditions. The petitioner fulfilled the criteria conditions and stipulated by the government. The conditions laid down as follows. Number one, the petitioner had the requisite qualification to be appointed as a teacher at the relevant point of time. This is for question. I have said they might come up with that I did not have the TET, but the TET was not required at that point of time. B, she has drawn salary from the date of her appointment till February 2012. She has the GPF account allotted by the Office of the Accountant General of Assam. She has passed the Junior Basic Training JBT certificate examination in 2011. And my lord, only one thing your lordship may note down, my lord. Similarly situated persons were given the appointment on accommodation on 31/2021. That may be noted, my lord. It is page 57. Second paragraph. The petitioner craves leave of this honorable court to produce a copy of the accommodation order dated so and so issued in respect of a similarly situated person falling within the category 3 at the time of hearing and or so called for. My lord, this order was issued on 31/2021, but it was with effect from 1/11/2020. That can be also noted down, my lord. This is in the order. A similar order is there, my lord, who in fact happens to be my cousin. She was given the benefit and I was not. And my lord, would your lordship be, if your lordship, I'm sorry.
This order is not part of the record.
No, which order, my lord?
This order?
Similar order?
Yes.
No. I can give it. My lord, would your lordship be pleased to come to page 78 only once, my lord? I'll just close, my lord.
Yes.
My lord, second paragraph. My lord, I'll just read 5 lines. In terms of the honorable court's final order dated so and so, passed in so and so, the education department placed the matter of regularization of irregular teachers before the cabinet in its meeting held on so and so, with a view to examine the nature of appointment, status of post, working status of salaries, academic qualification, etc. The Director of Elementary Education Assam invited applications from those illegally appointed teachers during 1991 and 2001 throughout the state by an advertisement dated so and so. My lord, this, would your lordship underline this period, my lord, 1991 to 2001? Why I say so, my lord? I was 1989. I was dragged inside this. My service was already provincialized in the year, regularized in the year 1995. And my service was regularized. Regularization order was issued in pursuance to the order of the Secretary to the Government of Assam Education Department 3695. That your lordship will find Paragraph 3 of my writ petition. That is page 4. May I read it, my lord?
Yes.
Paragraph 3, page 4. That the petitioner begs to state that on a due process of recruitment being initiated, the petitioner participated therein and appeared in the interview for selection of lower primary school teachers. In terms of the selection process, the Deputy Inspector of School, Dhemaji, regularized the service of the petitioner against a retired vacancy by order dated so-and-so 7/6/1995 with effect from 19/12/89. That is my day of appointment. Pursuant to the letter of the Secretary of the Government of Assam, Education Department dated 3/6/1995, and since then the petitioner has been serving against the said regular post. Now that is, annexure is page 21. Page 21, my lord, annexure 3. Srimati Deepika Dole, who is rendering service in Silapathar LP School continuously from the date of joining, that is 20/12/1989, as per the office memo so-and-so, issued by the Deputy Inspector of Schools in pursuance so-and-so, issued by the Secretary to the Government of Assam Education Department, the service of whom has been regularized pursuant to retirement of one Gyan Gohai of Gohai Khajua School with effect from the said date. Now, my in nutshell, my lord, I was appointed in the year 89. In Dhemaji, 1999, there were, in 91, there were a huge number of teachers appointed. When they were examining the 91 to 2001, they dragged me also inside that. I have communicated with them and served my every testimonial. After that, they have decided that a list will be, 3 lists will be made. One, the person having received salary up to 2007 and completed professional qualification of junior basic training. Second, salary up to 2007 but not completed the junior basic training. And another, neither received salary nor completed the junior basic training. I come within one. And then after everything is done, cabinet has given the approval. They leave out, do not accommodate me, and there is no reason at all. If your lordship has seen this order, nothing has been said, only said not approved. Why not approved? Didn't I meet the criteria laid down by the authority? Nothing. My lord, all in all, it was a wrong action and did wait till the finalization of the screening. Still, I'm sorry to say, my lord, I've been neglected and denied my rights, my lord. And if your lordship permits me, that if I'm allowed to give my lord similar order, if your lordship permits, then I can give it.
Okay. Mr. Sarma?
My lord, there is one letter is also there in the year 2019 from the Deputy Inspector of School to the director. So these are not, because the petition is of 2016. So these 2 documents, my lord, I'm just placing them. Deeply obliged.
But would you file it by way of an additional affidavit? So that he may also.
My lord, then only the similar which I have already said, already took the crave of this honorable court at the time of hearing, or as my lord asked that I can produce that order. Only that order can be given. Other one not needed. Only the appointment. Dada khali appointment from video. The order which has been said is regarding my salary that I have received up to 2012. Nothing else. It was just added. In the 2013, they said once, which is already there in the as an annexure. And now it is 2019 also. that communication was made saying that I received the salary up to 2012 and cutoff is 2007. That is the only thing I have to show, man.
Yes.
Lordship, before I take your lordship through to the academic lordship, may I take your lordship once again to the cabinet memorandum, page 17.
No, Mr. Sharma, you see, how the cabinet memorandum will cover her case.
No, it will not cover. Lordship, that is why I want.
But before that, her service has been provincialized.
No, Lordship,
declared.
that is what I want to show your lordship.
Hmm.
Cabinet memorandum once.
Hmm.
78 page, second paragraph, in terms of the honorable court's final order, dated so and so in publication of so and so, the education department placed the matter of regulation of illegal irregular teachers before the cabinet in its meeting held on so and so with a view to examine the nature of appointment, status of post, working status, status of salary, academic qualification, etc. of the appointments, director of elementary Assam by section number so and so, illegally, irregularly appointed teachers during 1991 to 2001. This is there. My learned friend claims to have been appointed in 1989. Now may I take a lordship to the next page, page number 79. The first paragraph. It is pertinent to mention herein that
Her date of appointment was 1989.
89. She claims to have been appointed in 1989. Now,
So the period is here 1991 to 2000.
no, that is why. Page number 79 once.
What is that I'm
Next
claiming?
paragraph. Next,
No, what is that I'm claiming? Your appointment order.
that is your claim. Lordship may take, kindly come to page number 79, first paragraph. It is pertinent to, I will lordship. It is pertinent to mention herein that in addition to 8471 teachers, these 847170 teachers was of 1991 to 2001. In addition to these 8470 teachers under category 3, in respect of 752 teachers of Dhemaji, the petitioner was appointed under Dhemaji district and Lakhimpur district, who were already terminated from service in 1992, along with 14 other teachers of similar nature. Herein was conducted in the office of the Director of Elementary Education Assam. All 752 teachers of Dhemaji and Lakhimpur districts were found to be illegally and irregularly appointed in the year 1989. It was not tracked. These teachers of Dhemaji and Lakhimpur districts, 752 plus 14 teachers were also illegally and irregularly appointed during 1989. So they come under this 1989 illegally appointed teachers. So these teachers were not dragged, they were also considered. Against non-existent posts. Thus, they all were terminated in 1992 by releasing their stipend of 29 months. They received a stipend of 29 months. All these teachers received stipend for 29 months, but they continued to attend the school illegally. During the screening process conducted by DE Assam, it was found that a large number of these 752 terminated teachers, along with other 14 teachers of similar nature, were absent from duties in their respective schools for a period of 6 to 7 years, but subsequently attended the schools illegally. Therefore, their position is also similarly placed, as in the case of the teachers of category 3, that is category of 800.
No, Mr. Kumar, do you have any document to show that
Lordship.
Her name is there in that list?
These 752 teachers.
752?
Lordship, at the moment, the list is not there, but here is of course a list. There is a list of 752 teachers that I can place before the Lordship on the next day. Okay. So these teachers were appointed.
No. Are you sure that her name is there in that list?
The list of teachers is there. I am not sure whether it is, according to our affidavit, she is there. Now may I take a lordship to my affidavit?
My lord, only thing I was never
What is it?
terminated.
No, Mr. Devan, please sit down.
May I take your lordship to my affidavit, additional affidavit? There are two affidavits filed by the respondent number 1. The second one, the additional affidavit
which my learned friend had just read out. May I take the lordship to page number? Lordship, 73. Page number 73. Paragraph 12. Where is Lordship?
Yes.
That the answering deponent humbly begs to state that, as reported, this is a affidavit filed by the secretary. Therefore, as reported by the Director of Elementary Education of Assam, by letter dated 28/4/2023, the petitioner was appointed as teacher in Silapathar Nagar LP School, Dhemaji, during December 1989 by then DI of School Dhemaji against a non-existing post, who falls under among the 752 numbers of teachers. So it is clarified here. Terminated teachers under Dhemaji districts who were paid salary for 29 months from December 1989 to May 1992. Thereafter, she was transferred from the Silapathar Nagar LP School, Dhemaji districts to Natun so-and-so districts as per instruction of the DE Assam, filed later dated so-and-so, and she received monthly salary up to January 2012. However, as per government instructions, filed later dated so-and-so, and DE Assam later dated so-and-so, it was instructed to keep on hold the release of salaries to all the concerned relating to 752 numbers of terminated teachers under Dhemaji districts, including those who were transferred from these districts to other districts. Accordingly, the release of monthly salary of the petitioners had been stopped from the month of February 2012, and her name was included in the list of 752 terminated teachers. It says that her name is there in the list of terminated teachers of 752 under Dhemaji district. Her case was then brought under the ambit of illegal, irregularly category of tutors. The petitioners appeared before the screening committee, and the case was screened on 19/4/2014 by the scrutiny committee as per instructions of the Divisional Commissioner, Upper Assam Division. But her name was not approved by the screening committee as she did not meet the criteria laid down in the cabinet memorandum. Hence, she was not offered accommodation. Therefore, Lordship,
How and why her
because
case
she was
not
on the
covered
list
by
of,
the cabinet
she was
member?
in the list of 752 terminated teachers. Now there were three criteria as list A, list 1, list 2, and list 3. It is not claimed to be there in the list 2, but according to the screening committee, the petitioner did not fulfill any of the criteria in order to be accommodated as teacher or tutor. Insofar as the list is concerned,
So, you produce the list of these 752 numbers of teachers and their termination orders. Can it be on Friday?
This Friday, lost. Lost. Lost not fixed next Tuesday, lost. Coming Tuesday.
No, this is of 2016 matter, therefore.
My lord, if your lordship permits me to say only one line. This my friend has just referred to page 74, paragraph 12. Is it, my lord, in front of my lord, my lord? My lord, if I was terminated in 92, then thereafter she was transferred from so-and-so to so-and-so in the year 2001.
These were all, as per record, these were.
This is, I'm not saying respondent number 1 is saying on oath. Is it possible, my lord, 92 I am terminated and 2001 I have been transferred and I get the salary up to 2012. And there is a document, my lord, if your lordship looks at page 63, page 64, my lord.
All
My lord,
illegally done.
whatever it is, my lord. Now see the page, my lord, page C64.
These are all illegally and irregularly done.
64. As per office of the so-and-so dated so-and-so, senior most so-and-so, an opportunity has been allowed to function as the full-fledged headmistress, and this is given to me. The Deepika Dole headmistress, so and so is hereby ordered to hand over complete charge. I was working as a headmistress at that point of time, 2014. My lord, I think this court will take it as a surprise that my friend is saying I've been terminated in the year 92, but in 2001 I have been transferred from that to that, and there is no break of service in as far as but there is no break of service as far as I am there. From the date of my appointment till 2012, I received salary continuously. Your cutoff is 2007. How I do not come within the criteria? Just don't deny a poor ladies before the court. And it's not that illegally claiming you are given the similar. My lord, that order I have given is a similar order, my lord. Exactly same person from Damaji. You can say only because of the court case that I have not been given. That I'll appreciate. Otherwise, there is no reason I should not be given, my lord.
May I place that 750 is lordship is verified.
Along with the termination order. Part, sir, awaiting learned counsel for the petitioner, Mr. P.S. Verma, the other subject counsel for the responsible elementary education department. Mr. Abedin has concluded his part of argument. While advancing his argument, Mr. P.N. Sharma learned consulting counsel for the respondent in secondary education department. The elementary education department has drawn the attention of its court to the OM dated. The cabinet memorandum dated.
This candidate memorandum was effective on 7/10/2020.
Cabinet memorandum dated.
My lord, that was the, the date is not there.
But it was approved on 7/10/2020.
7/10/2020.
Lord.
And commits that the petitioner, name of the petitioner is in the list of 752 teachers of Hemadi and Lakhimpur district. And they were terminated from service in the year 1992 along with 14 other teachers of similar nature. In view of the aforementioned submission of Mr. Sharma, it is provided that Mr. Sharma shall produce the aforementioned list of 752 teachers of Hemadi and Lakhimpur district along with their termination order before this court on Friday. Look, this is the list the matter is parted. Okay.
Deeply obliged, my lord.
Item number 15, parted matter.
May I please, Lordship, my lord? Lord, in this case, I am aggrieved by the, my lord, impugn order at page 97, my lord, and on last occasion, my lord. Lordship had directed the, my lord, government council to produce the, my lord, report, on the basis of which, my lord, this impugn order was passed, my lord. Whereas, my lord, the inspection report says something else, my lord, which is in my favor, which was passed by the SI of schools in the year 2016 and 17, where the number of students in the school was 160, my lord. And that was never disputed by the, my lord, government council, my lord. Now, whether the report is with them or not, I don't know, my lord.
Lordship, in this matter, last occasion, my lord, you filed the affidavit. So last time it was not taken up because of the additional affidavit which you have. And this matter, my lord, we have filed the additional affidavit, my lord. And that, my lord, people comes out. Page 106. There was a order which was passed on 7/11/2023, my lord. Wherein, my lord, the
direction was given to the Director of Elementary Education, basically deputy an officer, my lord, to have an inspection of this particular school. To scrutinize as to whether the, whether it's on paper or on correct on. Therefore, my lord, accordingly, the government deputed one deputy secretary officer, my lord, of the government of Assam, Department of Education, my lord. She carried out a spot inquiry, my lord.
Okay.
And that in that particular, my lord, of the Dakhin Padamani Pathar LP school. And my lord, when the inquiry was done, my lord.
Okay. Mr. Sonuri, you have been asked to produce the report.
Lordship, the son officer who is handling with the report, he was on leave. Lordship may take it up on Thursday or Friday. Friday.
Okay.
On Wednesday, 19th.
19 will be next in the current.
10 on Friday.
Friday.
Milord, otherwise, Milord, I'm submitting, Milord. This case has been listed on many occasions, Milord. From the materials itself, Milord, although Lordship had directed them to produce, Milord, the report, Milord. But there is a report, Milord, that is in the form of inspection report, Milord. That is in my favor, Milord. That was issued in the 16-17, Milord. That was disputed by, Milord, never disputed by none of the, Milord, government council and none of the authorities.
No,
Milord.
no, that report is not part of the record.
That report is a part of record, Milord, inspection
Right.
report. In the writ petition itself, Milord, inspection report, Milord. But the report that your Lordship has sought for, Milord, that is not with us, neither it is with them also.
And another thing which has to be seen, my lord, is that the as per order date 7/11/23, that order, my lord, the secretary, deputy secretary was deputed to make an inspection, my lord. That I have such an affidavit at page 109. That is the elementary. There, my lord, if your lordship comes to page 109, the inquiry is there. At page 109 is annexure 1. The on-spot inquiry of the school, it is found that the said school is kacha house and the walls and pillars are made up of bamboo with single roof. So it was in a very dilapidated condition. Your lordship, if your lordship remembers on the last to last occasion, your lordship we had submitted the report. Photos also are there. So your lordship had also said observed that looking at the photos, it doesn't look like a school. Your lordship had said. If your lordship report there. That is the elementary report. Then on the last occasion, your lordship has asked the SSA to bring their report. So that will be
Milord,
crucial.
this issue has already been resolved, Milord.
Yes.
Lordship will kindly see page 109 of my affidavit. Just lordship will see 109 of my. That is the report which we have brought on record, the elementary education, based on the judicial order. 109, annexure 1. Inspection report in connection with WPC 3521 of 22. This is the latest report, which inspection. The one which the petitioner is talking about, that is the old 17.
No, I'm talking about
He's
the
talking
latest.
17. I'm talking about, my lord, the latest one, which is the on which dated 30th January 2024. The Honorable High Court has passed an order dated 7/11/23, WPC 3521/22, so and so, wherein it is directed that the authority conduct an inquiry relating to the claim of the petitioner for provincialization accordingly. An inquiry of Dakhin Kadamani Pathar so and so was carried out on 29/1/2024 at 10 a.m. In spot inquiry of the school, it is found that the said school is kacha house and the walls and pillars are made up of bamboo with a single roof. The basic needs of the school are not available in the school and there is no environment of learning for students. Further, my lord, this is very crucial. No teachers and students were found present in the school during the class hour at the time of the spot inspection. This is crucial, my lord. No teacher and student is found during the inspection. There is nobody. The place was, my lord, abandoned. And my lord, since there is no teacher and students attending the school at the time of the spot inspection, the proceeding books and other documents relating to the enrollment of the school could not be verified. The condition of the school has been captured in the photo and attached. That photo we have given it submitted beforehand. The lordship had got it. Lordship had seen the photo also in the record. There was a report, my lord. Along with the report, the photos are there.
No. Along with the report, photos are not there.
I guess there only.
Why?
What is your?
Okay. Okay, this is in separate.
Separate.
But why it is not part of the report?
Because my lord, on the last occasion, I was actually, my lord, last to last occasion, I was on them, the other council has submitted, your lordship had kept it on record. Your lordship didn't reflect in the order, but your lordship kept it. Based on this, your lordship had said, the photo also doesn't seem to be, if your lordship remembers. It was in a dilapidated conditions and, no students, no teachers present, my lord. And in fact, in the affidavit in reply, they have admitted, my lord, that they were not
I'll
present
submit,
because of some
Admin.
reason.
Please don't tell my part. I'll submit before your lordship.
In reply also they have given, my lord.
My lord,
I will, after that. They have.
may I reply to this point, my lord?
Let him complain.
My lord.
first. He will get a son.
My lord.
So my lord, therefore, my lord, this is this regarding the elementary part, my lord, we, our stand is that, my lord, this school is not in a, my lord, the environment is not good, my lord, for students, my lord. It is in a dilapidated condition, my lord. And my lord, when the 7/11/23, my lord, when the court itself had directed, my lord, for an inspection, my lord, they were all very well aware that an inspection will take place, my lord. Accordingly, the inspection took place, my lord, and nobody was present there. My lord. That on a working day, my lord. The most crucial part is on a working day, the teachers were not there, the students were not there, nobody was there. And the reply which they have given, is that somebody was, lordship comes to page. Yes, sir. Lordship will come to page 113, the bottom paragraph. 113 of the affidavit filed by my learned friend, my lord, in the affidavit in reply. Page 113. There, my lord, if your lordship sees, the deponent petitioner Amos Samdi begs to state that in this connection that regarding the inspection of the inquiry of the school, no prior notice was served about. My lord, this argument I have demolished, my lord, because of the fact that order was passed, judicial order was passed here to conduct an inquiry. So already the council knew the people that there will be an inquiry done. They should have been present, my lord, during, as it is on a working day, they should have been present in a school, my lord. That part, my lord, the argument gets demolished there itself, that they were not given notice for. Second, my lord, and on that day of the inspection, he along with the only other teacher of his school, that is his brother, my lord. Coincidentally, the other teacher who is there in that particular school is his own brother.
Maybe.
Had to leave the school at 9:15 AM because of certain death of their paternal uncle. They haven't not informed anybody, my lord. They have not informed anybody. There's no other teacher there, my lord. And no application, my lord, was available, my lord, before the department authorities, my lord. Whether they have taken leave or anything. My lord, whether they have taken leave. There is a procedure, my lord. They cannot just shut down the school on the, my lord, as per their own wishes, my lord. So therefore, my lord, these two, their argument does not tally with, my lord, the report also, my lord, because the department went there, my lord, as per the directions of the court, my lord, conducted inquiry. No, the school was in a dilapidated condition. No teachers are present. No students are present, my lord. So on that basis, my lord, there is no environment, my lord, and this repetition is liable to be set aside.
I see. That's enough. May I submit, my lord?
Yes.
My lord, regarding the inspection report, my lord, your lordship has already, my lord, observed on many occasions. And lordship was asking them whether any prior notice was issued to us on any occasion, my lord. They said no, my lord. And unfortunately, my lord, on the day of inspection, my lord, one of our, my lord, paternal uncle, he had succumbed, my lord, for which, my lord, we had no time to inform any superior authority. And the school is at venture stage, my lord. Therefore, my lord, in a hurried manner, my lord, we had to leave the school, my lord. And unfortunately, on the same day, my lord, the inspection was shown to be carried out, my lord. But the picture, my lord, that has been produced before your lordship, my lord. If I take your lordship to page 117 of my affidavit in reply, my lord, lordship will kindly have a look, my lord, for a moment, my lord. This is the, my lord, front photograph of the school, my lord. The photograph that they have taken, my lord, God knows from which corner and which angle they have taken the photograph, my lord. This is the original photograph of the school, my lord. And regarding the, my lord, impugn order, my lord, by which I was aggrieved, my lord, that was passed in the year 2022, my lord.
The question is, when this photograph was taken?
Which photograph, my lord? This
Which
was
photograph you have-
recently taken, my lord. I have filed, my lord, my affidavit in
sorry.
reply, my lord. Recently, my lord. Just before filing of my affidavit in reply, my lord.
Then when the inspection was conducted?
Inspection was, my lord, shown to be conducted, my lord. Probably, my lord,
29/1/20.
29, my lord. Recent, my lord, both are. Inspection is also, my lord, not very, my lord, late stage, my lord.
After the passing of the order.
My lord, at least they should have issued, my lord, a prior notice to us, my lord.
No, the judicial order is passed.
They have never issued, my lord, any notice, my lord.
Order is passed, they already have got the.
Regarding the impugn order, my lord,
Sir,
let me submit.
you see, there was one judicial order
Yes, my lord.
for conducting an inquiry with regard to the enrollment and condition of the school of the petitioner.
Yes.
So this order was passed on 7/11/2023.
Yes, my lord.
So in your presence, this order was passed,
My lord.
then why you remain absent in the court on, in the school premises on that day?
Because, my lord, we did not know, my lord, on that specific day, the inspection will be carried out, my lord, because no notice was issued to us that on some particular day,
No,
the authorities will carry out
no,
the
no.
investigation.
They have visited your school on a working day.
On a working day, my lord, and unfortunately, my lord, without issuing notice for which we are not aware of the fact that on that particular day, my lord, the inspection will be carried out, my lord.
And having gone through the photographs that have been enclosed with the report.
Therefore, my lord, the authorities could not verify the, my lord, the other official records of the school, my lord, since we had to remain absent, my lord. I had admitted, my lord, on many occasions that because of some compulsion, we had to remain absent in the school on that particular day, my lord. Had a notice been issued, my lord, a prior notice, definitely would have deputed someone else, my lord.
While the order was passed in presence of both the council,
My lord.
why notice should be issued?
My lord, because the inspection was carried out at a, my lord, belated stage on a different date, my lord, after several months, my lord. There was a gap, my lord, after pronouncement of the judicial order, my lord. The inspection was carried out on a, my lord, after 3-4 months, my lord. Lord, she will kindly compare if necessary, my lord.
Therefore, the report has to be disbelieved.
No, my lord, report has to be not has to be busy. I am admitting that on that particular day, my lord, we did not, we could not remain, my lord, present in the school. But the photograph that they have produced, my lord, that itself is, my lord, absolutely, my lord, fake, my lord. Lord, she will kindly have a look in my photograph. This is the present photograph of the school, my lord. And regarding the, my lord, impugn order, my lord.
No. Why should we disbelieve the photographs that has been enclosed with the report that was furnished by a government official?
My lord, this is also, my lord, then lordship will kindly.
The inspection was also conducted pursuant to an order passed by his court.
Yes, my lord, I understand, my lord. Lordship, then can we do one thing, my lord? During the pendency, my lord, another, my lord, inspection may kindly be carried out. My lord, where after, my lord, in presence of, my lord, the petitioner, my lord, as well as the official authorities, my lord, the whole picture will come out, my lord, the real picture, my lord. I am producing a, my lord, complete photograph. They are producing a, my lord, half photograph, my lord. This has been disputed by the official authorities, my lord. Let me do it, my lord, let it be very clear, my lord. If a fresh investigation is carried out, everything shall be very clear, my lord. Because of my absence, my lord, the proceeding book of the school, the teacher's attendance register and other documents could not be verified by the official authorities, my lord. Hence, my lord, they are disbelieving, my lord. Our contention is very clear, my lord. Let them issue a notice, my lord, and let them conduct a fresh inquiry, my lord. Everything shall come into light, my lord. It is not that we are running a fake school, my lord. We are not having the students in the school, my lord. Because of the, my lord, dispute with another person, my lord, as regards the genuineness of the school, my lord, several number of litigations, my lord, occurred, my lord, on earlier occasions. And finally, my school was declared to be the genuine school, my lord.
will also consider the one more aspect, my lord, that the conduct of the teachers. School, when, my lord, when it is run, there's a procedure of running a school, my lord. Somebody's relation has died, that does not mean that the institution will be closed in a, my lord, half-assed manner.
Not
There
half-assed
has to
manner.
be an application
They-
given to the, my lord, concerned district, my lord, officials, my lord, of the elementary education, my lord. There is a procedure, my lord, proper procedure. They have not followed that. They have randomly, my lord, and coincidentally, the other teacher who's there. and
Maybe.
There should be other teachers also, my lord. There has to be some other teachers, my lord, if it's a venture, my lord. So they should have deputed somebody who is
Arey,
there, my lord. There's nothing of
listen,
that sort
brother.
has been done. My lord, nothing of that sort has been done. This is not a way, my lord, a school functions, my lord.
Lord, had
So
there
that-
been a
that
prior
aspect-
notice,
this aspect
we would
has to
have
be looked into.
definitely engaged someone, my lord, to be
Conduct-
present in the school, my
conduct,
lord.
my lord, and
Unfortunate, my lord.
had we, this is, my lord, a judicial order has been passed, he has been, he knows that. an
No,
inspection
then
will be-
inquiry was not carried out on time, my lord.
My
After
lord,
several
judicial-
months, my lord, it was carried out.
That also we have.
That
an
too
argument,
without
my lord.
issuing any notice, my lord.
There is no date given, my lord.
At least, my lord, I have prior notice.
There
I
is
have
no
a right
date
to know,
given.
my lord.
Specific date, my lord.
I have a right to know that on some specific day, the inspection shall be carried out, my lord.
The school was not functioning properly, my lord. There are a lot of, my lord.
That right has been curtailed,
there
my
are
lord.
Great irregularities, my lord. You can see, my lord.
No,
That part, the lordship will kindly look into. While considering this case.
otherwise, my lord, my case is very clear, my lord. The records are very clear. I have produced the, my lord, number of, my lord, applications, my lord. Because of which, my lord, because there was a dispute for which the earlier Dias Code pertaining to the year 2009-10 was not neither released nor it was issued afresh, my lord. In fact, the DEO he has also, my lord, made a communication to the concerned, my lord, director, my lord, regarding this aspect, my lord. My lord, I am otherwise affected by the impugn order passed in the year 2022, my lord. And this inspection has been carried out, my lord, on recently, my lord.
Mr. Hamad, you see,
My lord.
this impugn order was passed on the basis of the report.
Yes, my lord. But why the photograph of the school, my lord, has been produced in such a manner, that is beyond my understanding, my lord. Therefore, I am humbly praying before your lordship, my lord. Let
No,
there
no,
be
no,
another,
no,
my lord,
it is
inspection, my lord.
their prerogative, how can they furnish?
And let there be a, my lord, prior notice from the official authorities that they will conduct an examination, an inquiry, my lord, on a specific date, my lord. Everybody shall remain present, my lord. Unfortunate, my lord.
Since the.
Because of a sudden demise, my lord. There are only 2 teachers in the school, my lord. They had no time to inform the higher authorities, my lord. It is very unfortunate, my lord.
Mr. Sodri, when you will be able to produce the report? Friday. Friday. Right.
But the person was on leave now, so he'll be certainly to inform.
Or Mr. Hamad Garnet counsel for the petition. Subject counsel for the respondent number 126. 126. So Sodri, Garnet standing counsel for the respondent number 3 and 5. And none appears for the respondent number 4. It appears that high order dated 23rd of October 2025. Sodri. Garnet standing counsel for the respondent number 3 and 5 was directed to produce the report. Regarding enrollment in the school of the petitioner during the year 2016 and 17. But Mr. Sudhuri submits that the person concerned who has been dealing with the file is on leave, and on account of the same, the file would not be produced, the report would not be produced today. Then he pressed for listing the matter on Friday. Where is allowed, recessal list the matter on Friday.
14th, 11th. Item 17.
Lordship. Here in this matter, I appeal for some methodical law. The last year, my lord had come with a P46.
was directed to obtain an instruction as regards the verification of the dash data, two dash data, whether that dash data was of the petitioner or not, there were two dash data, so that they are verifying lordship. So, short accommodation lordship, once that report is received, basically, in fact, on seven director also directed the district executive.
Or Mr. M.A.I. Hussain, Learned Counsel for the petition. And Mr. P.N. Sharma, Learned Central Counsel for the department. Mr. Sharma submits that. May be granted some time to produce the report. The produce a report by the District Elementary Education Officer Durham after verifying the fact whether Azhar Ali, whose name appeared in dice data for the petitioner's school since the year 2009/10 till 2013/14, and Azhar Ali, whose name appeared in the dice data since the year 2014/15 to 14/15 up to 22/23 is the same person or not. And the said report is not available, then you guys for listing the matter on
24th November.
24th November. Where of Mr. Sharma is accordingly allowed. This is a brief of matter of. So as to enable Mr. Sharma to produce the report. List accordingly.
Item 18, order letter.
What was the direction of this court?
Lordship, that is, I have to give it this photocopy. Lordship, may kindly peruse paragraph
Property
20,
part?
paragraph 21, Lordship. The
21.
judgment, page 9. So.
So this order is silent regarding the date.
Yes, Lordship. Regarding the date from which he will be entitled, that was fine. In that order, no specific direction was issued. Only the last
But
line.
your order is mainly based upon the opinion given by the judicial.
Judicial. Because the order passed by the learned single judge on 14/9/23, that order has only stated that he would be entitled, if he would retire on 30/4/22. That is, but no specific, that is why after taking the views of the judicial department has come to a conclusion that this will be the right, that the date from which he has absent from his work. Because after that, if the date is being calculated, then it will be treated as service, but he is absent without any information. The department has followed the principle of no work, no pay. Based on that, he is being entitled from that date on, the last date in which he had worked.
The pension has to be calculated from the day of compulsory retirement, 1/1/2011, my lord. That has to be done.
That is why.
If that is, if they accept that they will grant from 1/1/2000 effective date of effective my date of dismissal, then pension compulsory retirement, then whatever post compulsory retirement benefit that will follow from that date. That is the thing.
Are you extending the benefit from that day?
Lordship, it is clearly written that if your lordship permits me, the judicial department opined that if the order of dismissal is converted to compulsory retirement as per honorable court order, the effective date for compulsory retirement would be the date of dismissal, that is 1/1/2011. In our speaking order, it has been clearly stated that the date is 1/1/2011. The speaking order.
No, that's all right, but are you extending the pensionary benefit from that day to the?
Yes, Lord, from that date only. From that date only.
They will.
Yes.
The lord will dispose of by directing them, my lord, from following that day.
2011.
Yes.
Yes, in the speaking order also it's written last line. Lordship.
Page number?
Lordship, the
30.
last line, Lordship.
Page number 30.
Page number?
30.
30.
Last paragraph.
Now, therefore, in view of the observations, the Department of Justice Affairs Involvement considers this to be a
Yes, it is already stated in the order.
Lordship?
It's last line.
Yes.
It is further directed that the pension of Cotton Chandra Kolkata be granted as per law. As per law means from that day.
That day. But they informed my lord, they will grant the benefit with effect from pension of 2011 will be given with effect from his date of retirement. That is why my lord clarification is required. That is the
Yes, Lordship, because
the lordship will clarify this.
judge has already stated his pensionary benefit will be calculated from 1/1/2011, but it will be taken as from 34/22. Because he has not had on that date, because if you
According to you, from which date he will entitled to this pensionary benefit?
Lordship, he will be entitled for pension with the date from 1/1/2011, but it will be calculated, means it will be effective from 34/2022.
No, that cannot be the.
Because the balance period from 1/1/2000 means, the balance from 1/1/2011 till 34/2022. He has not worked, Lordship. During that period, he was absent.
That's all right,
Because
Compulsory retirement, my lord,
absent
retirement
period-
from that day.
Absent period, an employee cannot be treated to be in service, Lordship.
No, he cannot be treated in
In
service.
service.
That is why, let's say, the department has followed the principle of no work, no pay. But since he was supposed to retire, because
From
the Lanet single judge has.
No, from the date of compulsory retirement, he will be entitled to the pension and other pensionary benefit.
Yes.
Lordship. No, he was supposed to retire on 34/22.
No. That cannot be.
Because
You have converted his dismissal from service into the
Compulsory
retirement. Compulsory retirement, you have counted it from that day.
Yes.
Lordship.
From which he is dismissed from service. Then he will entitled to the benefit from that day.
He will be entitled for benefit, only for the pensionary benefit, he will be entitled, but his pension will be calculated from 34/22 only, because the balance period, he was in absent only.
No. That
Because
cannot be. That cannot.
the
Once
speaking
the
order-
retirement-
If the speaking order, Lordship may follow the speaking order. The fact finding, everything is there, Lordship. Because Lanet Single Judge has considered this case on sympathetic ground, not on merit, Lordship, because it's reflected in the order itself, passed by the Lanet Single Judge. No fault in the disciplinary authority, nothing is there.
No, that's all right. There is no doubt about it. Mr. Chakraborty, you are for AG. Any submission on this point?
They have to send the papers, he was there after our action.
No, regarding their submission.
But not if the order there is, order sent that there is no court. So to keep some relief on the protected ground, that was converted.
So according to you, from who is that the petitioner is entitled to the pension and pensionary benefit?
But the orders is from 2011, but maintenance is like.
How?
That is the date of.
No. he has been dismissed from service in the year 2011. And that punishment has been converted into compulsory retirement. So from who is that he will entitle? From that day only. Is there any doubt about it?
That will be affected then, but if that compensatory pay is
From that day, he will be entitled to. From who is that he has been dismissed from service and
Yes.
converted to compulsory retirement.
Because it will come with the area pen.
Pardon?
Area pen will be included.
Yes.
But his date of retirement was 34/20. Then for that. I need
From
some-
that day, otherwise he will entitled to salary.
Then I need some clarification, or otherwise, a huge amount of the government expenditure will be.
My lord, date of compulsory retirement is given with 1/1/2011. After that date, my lord, the question of rendering service, no work, no paid, these issues will not arise.
Does not arise. Does not arise. And you cannot deny him the pension and pensionary benefit from that day. So, okay, you obtain instructions then.
Yes, sir. I will.
Or professor or net for the or RF plus planet okay for the society. Justice and empowerment part. Mr. Supportive for AG. Pardon first. This come letter on next Monday. So as to enable Mr. Das to obtain instruction as to from who is that the petitioner will be entitled to pension and pensionary benefit. Please record.
Item 19.
My pleasure. Matter relating to my lord ad hoc appointment, the post of headmaster. The affidavit in opposition has been filed and was in file, my lord.
You have received the copy?
I received copy, my lord. Replied, my lord, no such. My lord, kindly see the reply, my lord. They have stated as we stated in the writ petition, only, my lord, they could not stated how and why their latest action has come. Because, my lord, the petitioner appointed as in charge headmaster of Kasari High School, Masar, in the year 2018, after declining the post by the respondent, my lord. Respondent number 4, my lord. He was the senior most teacher, my lord, but he declined to take the charge, my lord. Thereafter, my lord, authority appointed the petitioner as headmaster in charge, my lord, of the school, my lord. At that time, my lord, the qualification was the same. Later on, my lord, 2021, my lord, respondent number 4, my lord, obtained B.Ed qualification, my lord, and he submitted a representation for the post of in charge headmaster, my lord. Then he came before this honorable court, my lord, with a writ petition, my lord. Writ petition number 1288/2023, my lord. This honorable court, my lord, remanded the petition to the authority, my lord, director, my lord, to verify and pass an speaking order, my lord. The director, my lord, pass an speaking order and allowed to continue the petitioner as in charge headmaster, my lord. And my lord, order 9/8/23, my kindly see the page 27, my lord. My lord, last paragraph. In the interest of public service, decision was taken in favor of the
Page number
page 27, my lord.
20.
27, my writ petition, my lord.
Yeah.
My lord, can you see consequent upon the expiry of the present headmaster Mohiuddin of Kasari High School, the inspector of school submitted a proposal for placing a new headmaster in charge. Upon verification of the seniority list, it was found that Sri Mintu Kakoti, the respondent number 4, yes, he was the most eligible senior teacher, but Mintu Kakoti submitted a prior petition showing his unwillingness to hold the charge of headmaster in charge. As a result, in the interest of public service, another teacher, Abdul Muttalib, the present petitioner, my lord, who was the next senior teacher after Sri Mintu Kakoti, was allowed to hold the charge of headmaster in charge of Kasori High School. Later, Mintu Kakoti filed a case before this honorable court in WPC number 1288/2023, claiming his seniority over the other teacher of the school to hold the charge of headmaster in charge of Kesuri High School District, Nagaon. In the interest of public service, decision was taken in favor of the next senior teacher, that is Abdul Muttalib, to allow him to hold the charge of headmaster in charge. Sri Mintu Kakoti submitted a petition showing his unwillingness to hold the charge of headmaster in charge. As such, Mintu Kakoti lost his seniority over the other senior teachers of the school. Hence, Mintu Kakoti's claim for seniority over the present headmaster in charge, Sri Abdul Muttalib, cannot be considered. My lord,
No,
There
on
are
this
from-
ground of whether the person concerned will lost his seniority.
yes, my lord, because he declined to hold the charge, my lord.
Your Lordship, we
As per their,
filed in our affidavit and we have taken this stance, your Lordship. First, your Lordship, your Lordship, this is an ad hoc, your Lordship. Ad hoc basis, your Lordship, and moreover, the rules which are specified in the book, your Lordship, is 14, which is, I have mentioned in page 33 of our affidavit in opposition, that is paragraph A. Eligibility
No,
criteria.
Just let Mr. Atia to complete.
My
his,
lord. My lord, can you see the Pawar case, my lord? My lord, one ad hoc cannot be replaced by another ad hoc, my lord. Yeah. My lord, can you see? Paragraph 18, my lord. Having considered that at the relevant point of time, 9/9/21, Srimati Meena Goswami was not having the qualification of B.Ed degree, which is one of the collection of consideration of the promotion to the headmaster, to the post of headmaster. In my considered view, order dated so and so appeared to be per se not illegal. At the same time, since Srimati so and so acquired the B.Ed degree on date so and so, she being the senior, the subsequent order allowing her to hold the headmaster in charge is equally per se not illegal. However, the court cannot lose sight of the settled position of law that an ad hoc cannot be replaced by another ad hoc employee, and he can be replaced only by another candidate who is regularly appointed by following the regular procedure prescribed. Same issue, my lord, in this case.
No, admittedly, the respondent number
4,
4 is senior to you.
senior to me, my lord.
Yes,
As
but the
at
question
the
is
initial,
merely
my lord,
because, no, Mr. Atia, you see, merely because he declined to take charge of the in-charge headmaster, whether he will lose his seniority.
actually,
there any
my
rule?
lord, can you see the speaking order of the
No.
authority, my lord?
Speaking order is there, but whether it is backed by any rule or any.
Yes, my lord. The my lord, Supreme Court also in Manish Gupta's case, my lord. Lord. Hmm? Hmm? Let me see. That's perfect. How to start? Manish Gupta. Hmm?
Yes, is it available with you?
My lord. Rule is, my lord, it's not with me, my lord. As per decision of the Supreme Court, my lord, no ad hoc can be replaced by another ad hoc.
No,
The-
that's all right, but whether
My lord-
that proposition will help you in this petition?
My lord, because my
Because
lord,
here the facts are peculiar.
he may, my lord, respect number 4 may appoint regularly, my lord, I am no objection. Because, my lord, he
But
declined.
indisputably, he is the senior most person.
He is the senior most, no doubt. my
But the question is whether he will lose
He-
his seniority.
Yes, my lord. As per decision, when speaking order, my lord, he lost his seniority.
No, no.
Director,
Yes, madam, whether there is any rule
also,
that if anybody refuse to take charge of the in-charge
what does
headmaster,
it?
he will lose his seniority. You see the order dated 9/8/2023.
The director secondary education
The last three
speaking
line.
order. At this stage, my lord, seniority is, my lord, not considered because of the appointment of in charge headmaster, not regular. Uh,
One petition is given your lordship by the earlier Mintu Kakote, showing his unwillingness to hold the charge of the headmaster in charge, your lordship. As such, he has lost his seniority over the other senior teachers of the school. Hence, your lordship.
And subsequently, by order dated 29/7/2025, he was allowed to hold the charge.
Under what circumstances, my lord, this order has been passed, my lord? Recent order, my lord, impugned order, my lord. Under what circumstances?
Your lordship, in our affidavit, your lordship, page 31, paragraph 4. We have stated that there is a consequence upon the demands of regular headmaster of Pastori High School. The inspector of school, NBC Noga, submitted a proposal for placing of headmaster, continuation in page 32, in charge of the same school, which was quite later dated so and so, issued on dated 12/9/2018, which I have already annexed it as annexure 1 in page 36. It was from IS Nogam, Midul New, addressing to ESC, your lordship, regarding inspector in charge, headmaster of Kashuri High School, Nogam, where it was clearly stated that with reference to the subject cited above, I have the honor to forward here with an application in original along with the seniority list of senior teachers of Kashuri High School, Nogam, received from the president of SMBC and the entire teachers of the state school regarding its appointment of in charge headmaster of the school. As the present headmaster, Mohiuddin has expired on dated 7/9/2000. A photocopy of that certificate is also proposed. And thereafter, your lordship, the next senior teacher is the petitioner. In paragraph 5, we have stated that accordingly to the list, your lordship, the next senior most teacher, Sri Abdul Muttalib, which is a BSc assistant teacher, was allowed to hold the charge of headmaster in charge of Kasuri High School by the issuing later dated order so and so dated on 9/10/2008. That copy of your lordship, we have annexed it, your lordship, in annexure 2, which is on page 37 of our affidavit itself. There, your lordship, order has given your lordship by issuing one letter, your lordship, that until further order, Abdul Muttalib, assistant teacher of Kasuri High School, district Nogam, is hereby allowed to hold the charge of headmaster in charge of the same school, along with financial power to draw and disburse the salary, etc. of the staff of the school in addition to his normal duty as assistant teacher under FR 49C as due to Mohiuddin headmaster expired on dated 7/9/2018. This is, and it is clearly mentioned in that order, your lordship, which was issued on 9 October 2018. This is purely temporary arrangement. It's no hold of permanent, your lordship. Thereafter, your lordship.
My lord,
Again, it was. Paragraph
oh,
6
it is general,
of our
okay.
affidavit in
General
opposition.
government
It
like
was
principle of the department of personnel
mentioned
and
that
training.
subsequently, in the year 2021, he obtained his BA degree on deputation and submitted a representation for being allowed to hold the headmaster post in charge of Kasuri High School. Not being considered, he preferred a writ petition. Your lordship, that's earlier, your lordship, Mintu Kakuti, which name was reflected, your lordship. He preferred for writ petition as he was not being considered by writ petition being number 2891/2024 before the honorable. In continuation, your lordship, page 33 of our affidavit in opposition, paragraph 7. It was stated that during the pendency of that case, your lordship, a revised seniority list was again called, your lordship, on dated 16/7/2025, which was furnished by the inspector of schools Nogam, where it was found that Abdul Motlib, the present petitioner, holding BSc 80, was not eligible to hold the charge of headmaster due to non-production of the mandatory BA degree. That is mandatory compulsion, your lordship. Mandatory BA degree is necessary, your lordship.
And that's for regular headmaster, not for the in charge headmaster.
Due to non-position of the mandatory BA degree. And thereafter, your lordship, as per the prescribed rules, that is also we have taken our stand in this affidavit, your lordship, paragraph 8. As per rule 14(2) of Assam Secondary and Provincialized School Service Rules 2018, the eligibility criteria for the post of headmaster superintendent in high school, high madrasa are as follows. Subclause A, your lordship, he must be BA, BSc, BCom with BA degree from any recognized university. In respect of Hindi teacher, having degree qualification of Hindi Parangat and Nishangat shall be considered instead of BT and BA, your lordship. Hindi Parangat and Nishant is also, your lordship, considered instead of BT and BA. Your lordship, in respect of Hindi teachers. And thereafter, one most eligible criteria is that, your lordship, he must experience of 10 years of teaching experience.
Okay.
As graduate teacher. So here,
Yeah,
your lordship,
you want to be
in
like-
9th, your lordship, paragraph
What to do?
9 of our affidavit, it is clearly
You will
mentioned
do
that BA 80
Yeah.
duly qualified with the required academic and professional qualification, which was found eligible to hold the charge of headmaster, your lordship. As per the list, your lordship, given list, your lordship, and your lordship, as Mintu Kakuti, your respondent 4 has preferred one writ petition, that is 2891/2024 before this honorable court. We have again revised the seniority list on dated 16/7/2025 as per furnished by inspector of school Nogam. Thereafter, it was found that the present petitioner is not eligible to hold this post. And thereafter, your lordship, as per the prescribed rules of the Assam Secondary Education Rules, your service rules 2018, the following, your lordship, criteria should be needed to match, your lordship, and where that respondent number 4 has academically as well as professional qualification was found eligible to hold the charge of headmasters. And here, your lordship, one relieving, your lordship, was issued, which was I stated in paragraph 10 of my affidavit in opposition. that the answering deponent humbly begs to state that accordingly, Mintu Kakoti, that is respondent number 4, assistant teacher, has been allowed to act as headmaster in charge of Kashori High School. Continuation to page 34. School Noga, relieving Sri Abdul Mutlib by this office order dated, which I already annexed as annexure 30, as annexure 38 and 39, as annexure 3. Marked as annexure. So order has already been stated, Your Lordship, that he has not qualified in academic as well as professional. Because Your Lordship, 10 years fulfillment of teaching experience also, he did not complete Your Lordship as graduate teacher. It is a crystal clear, Your Lordship, that he has not been qualified.
Yes,
My lord, kindly see my petition paragraph 9, my lord.
Yes.
The petitioner respectfully beg to state that the respondent number 4 again, my lord, again approached this honorable court with a writ petition being WPC number 2891, 2024. Earlier was 2023, my lord, 2024. Assailing the above speaking order dated 9/8/2023 and paying for quashing the said speaking order and a direction to be issued to the Director of Secondary Education Assam to set aside, quash the said order and allow him to hold the charge of headmaster in charge of Kasori High School, Nagaon. The above writ petition filed by the respondent for is now pending for disposal before this honorable court. My lord, pending disposal of this writ petition, my lord. In this writ petition, my lord, your lordship, my lord, asks them to submit the report and file the affidavit in opposition. My lord, they delayed the matter, and lastly, my lord, without filing affidavit in opposition, they passed the order, impound order, my lord. And my lord, in this writ petition, my lord, this honorable court nowhere stated or nowhere directed them to file fresh seniority list or consider the petitioner case, my lord. They have not submitted the affidavit in opposition. Instantly, my lord, they
No, that's all right,
pass.
but whether.
And my lord, this loss of seniority, my lord, actually regarding loss of seniority, I'm sorry, my lord, I generally governed by the principle of the Department of Personnel and Training and are reflected in specific service rule. Loss of seniority, if a senior employee refuse to promotion.
No. Insert headmaster post is not a senior or promotional. post.
Yes, not a promotional post.
Then.
Actually,
How that office memorandum or the decision of any court will help you?
well, kindly see, my post is ad hoc, temporary post. And no temporary post can be replaced by another temporary appointment. Madam.
No, that's all right, but here the circumstances are quite different.
My lord,
You
kindly
are
see,
not the senior most teacher.
yes, madam. He is the senior most teacher, my lord. At the initial stage, my lord. His qualification, my qualification is okay. Madam. He obtained the B.Ed degree later on, 2021, my lord. After he obtained the B.Ed degree, my lord, he submitted a representation before the authority.
In order to
Actually,
hold the post of insert headmaster, whether B.Ed degree is required.
no.
Then.
No.
Then.
Therefore, my lord, his claim is not maintainable, my lord. He is claiming that he is senior because of he obtained B.Ed degree. My lord, B.Ed degree will be required for the regular post, my lord. He may demand for regular appointment, my lord. And ad hoc, I am an ad hoc, he cannot claim another ad hoc post. My lord,
That principle may
in,
be applicable.
in my lord, can we see,
Yeah.
in Meena Goswami's case, my lord, everything is clearly, my lord, stated that, my lord, ad hoc cannot be replaced by another ad hoc, my lord. Everything, why cannot replace, my lord? Yeah, the reference
No, there
are
also-
made in this with the
There also it has been observed that it is well settled. Where it is settled then? You show me the.
Kindly see, 14, Meena Goswami's case, paragraph 14, recruitment to the post of vice principal, headmaster, headmaster,
Mr. Atia,
my lord,
you see in paragraph number 18 of that decision is observed.
my lord.
However, this court cannot lose sight of the settled proposition of law.
My lord.
Where the law is settled.
There is a court order, my lord.
No, that's all right.
Yes.
Produce that order.
And,
produce that
Supreme
settled
Court,
proposition.
Supreme Court also, my lord. Supreme Court also, my lord, in Monish Gupta's case, my lord, clearly stated, my lord, kindly may I read, my lord? Supreme Court Monish Gupta's case, my lord. I have one copy, sorry, my lord.
Okay.
My lord, paragraph 12. A perusal of the advertisement dated 24, so and so issued by the principal government Kamala Raja Girls Postgraduate Autonomous College, Gwalior, which is at Annexa so and so Apex appeal paper book and advertisement dated so and so issued by the principal SMS Government Middle School College, Gwalior, so and so, which is at Annexa so and so, would show that the appointment were to be made after the candidate had gone through due selection procedure. Though Sri Nataraj learned SD has strenuously urged that the appointment of the appellant were as guest lecturer and not as ad hoc employees. From the nature of the advertisement, it would clearly be seen that the appellants were appointed on ad hoc basis. It is a settled principle of law that an ad hoc employee cannot be replaced by another ad hoc employee, and he can be replaced only by another candidate who is regularly appointed by following a regular procedure prescribed. Can we? First paragraph.
Paragraph number?
Above paragraph, but first.
Okay. Mr. Bhuya, you are for the respondent number 4.
Present Milord, I am holding the charge of the headmaster of the school, Milord, being the only eligible and qualified incumbent working the school. Milord, with all respect to the submission made by my respected senior friend, Milord, not generally writ petitions are being filed, Milord, for the violation or for the enforcement of the fundamental right. Now, Milord, that right accrues, Milord, when a person is eligible and qualified for the purpose to hold a particular post, Milord. Now, under the rule of 2018 or the earlier rules also, Milord, for the purpose of holding the post of the headmaster in these categories of school, Milord, B.Ed degree is a mandatory and essential qualification, Milord. So therefore, once an incumbent, Milord, who do not have the, Milord, B.Ed degree at this moment, Milord, he cannot, Milord, says that I should be given the charge of the said school. It is the administrative discretion of the department, Milord, whom they fit and proper for the purpose of temporary arrangement. Now, Milord, the issue of this ad hoc, which has been, Milord, urged upon before my lordships, Milord, is also not maintainable because, Milord, ad hocism should be compared between two at par candidate, Milord. Now, a person, Milord, who has even not the basic qualification, Milord, that is the B.Ed, he cannot harp upon the ground of ad hocism, Milord. That has been well settled, Milord, in our this honorable High Court also, Milord. In Jagannath Tegu's case, my Lord, can in the writ petition itself, reference is there in an order passed by this honorable court. I am just troubling my lordships with page 26, Milord. Page 26 of the writ petition, Milord. These two cases are the landmark cases of our High Court, Milord. In that regard, Mr. So-and-so, my Lord, got it, Milord. I am reading in paragraph 3, Milord. In that regard, Mr. So-and-so, the learned counsel for the petitioner placed before the court the relevant judgment passed in the case of Jagannath Tegu versus State of Assam and others reported in 2007, 3 GLT so-and-so, as well as the division bench judgment passed in the case of Mr. So-and-so, so-and-so, so-and-so and others. Relying on the provision of so-and-so, so, Milord, these are the two judgments wherein, Milord, this honorable court has held that a person who is required to hold of the post temporarily, he is required to have the basic qualification for the purpose of promotion or to hold the post permanently, Milord. So then only, and Milord, and charge of a particular office can be offered or given to him. Now here is a case, Milord, they do not have the B.Ed degree, Milord. So therefore, once they do not have the B.Ed degree,
Whether this B.Ed degree is required to hold the post of external headmaster.
yes, Milord. In these two judgments, it has been held categorically, Milord, by this honorable court, Milord.
Okay.
Milord, if my Lord give me 1 day time, Milord, I will produce the entire bunch of judgments, Milord, wherein it is very clearly law has been laid down, Milord. Specifically for this post of headmastership, these two judgments has been delivered, Milord.
Okay.
My Lord.
So you produce that
My Lord, my Lord.
by tomorrow?
By tomorrow, Milord, I can produce.
Okay.
Or my Lord, may I pray to fix this on coming Thursday, Milord?
Tomorrow, the number of cases are not very high.
Then, my Lord. Then. Just to know.
Art Minister is here, for the petitioner. Peters here. Secretary Education Department. That is the year we are learning for the Supreme Court. In the course of deliberation, sir, we are have to refer to decision of this court in Jagannath Tegu versus State of Assam and others reported in 2007, 3 GLP 389, and a decision of division bench of this court in Mohammed Anwar produced Mehdi versus Abdul Matlib and others reported in 2016, 5 TLR 52. And he tries for granting him 1 day time to produce the aforementioned decision, which are very much relevant in the present case. Chair is accordingly allowed to recess and raise the matter tomorrow as parted.
And my lordship has also recently delivered a judgment, my lord. That, my lord, Sanatan Talukdar case, that also I will produce.
Sanatan Talukdar is there. Sanatan Talukdar. Petition 122/24.
Obliged.
Right.
Yeah, please, your lordship. Lordship, order is complied. Please receive the area salary.
Complaint.
Complied. Yeah.
Part Mr.
P. Bora. B. Bora.
P. Bora. Learned counsel for the petitioner and Mr. Boya, learned standing counsel. Learned standing counsel for the respondent number 1 and 2. The learned counsel for the petitioner submits that the order has been complied with and the petitioner has received his area salary. And as such, his petition may be closed. Accordingly, taking note of the submission of learned counsel for the petitioner, this writ petition stands closed.
Deeply obliged.
21.
With the business, your lordship, hearing your lordship, we will be filing our affidavit in due course. Due course, affidavit is filed, your lordship. So it has not placed in records. A short date may be given, your lordship.
Okay.
Our affidavit is filed.
Heard, Mr.
MK Chaudhary.
Learned counsel for the petitioner. And also
Our
heard
Mohoria
he does learn standing counsel for the respondent in secondary education department. He does submits that the respondent in secondary education department has already filed their affidavit, but the same has not been taken with the record. And accordingly, she prays for listing the matter.
Lordship, let it be day after tomorrow. Actually, very short points they have taken. One is that they say that we have crossed the age during the pendency, of course. So we want to argue very simply that the legal right, it crystallizes on the day of filing. And secondly, it is for internship only. And the other thing what they're saying is that our MA we have taken during service. So therefore, shortly, just I'm asking for a short date.
14, Lord. 14. 14.
14 is okay.
Friday.
Friday. Obliged.
Items 22 and 23.
That's itself. Take with the affidavit.
Like item 22, I have filed affidavit in opposition to them, my lord. For respondent number 8.
Not on record.
File today, my lord. That is possibly not the record. And my name is also not reflected. Please, my lord. For respondent number 8, the respondent to long, my lord.
Okay, let it be the next week. Yes, madam. Pardon, sir.
P. Maria, your lordship. In item number 22.
Petitioner. And Mr. Dust for respondent number 8. Mr. Abedin for. Lordship. Abedin.
For 7.
Respondent number 7, Ms. Peters for. Respondent number. Who is appearing for the elementary education department?
Or not? Or not?
Mr. Katonia for respondent number 1 to 6. 1 to 6. Mr. Das submits that he has submitted. He has filed his affidavit in opposition today. That the same is not taken with the record. Accordingly, it is provided with the business method.
19th.
19. By taking the affidavit filed by the respondent number in. Then the other read petition, item number 23.
That is the under petition. There is a interim order, my lord, in that case.
Pardon, sir, Abedin, learned counsel for the petition. Who is for the respondent here?
My lord,
For preliminary.
The Catalonia for list this matter along with, is there any relation between the two petitions? How these two petitions are related?
my lord, the
32 and
related,
23.
related is that, in my case, my provincialization was cancelled. So I approached this honorable court against the cancellation order that is stayed. That is stayed. And then he filed a case saying that he should be appointed rather where I have been cancelled. So that case, in Musharraf case, my lord, there is a pleadings are exchanged. I'm going to file a counter to, I'm going to file a reply to the counter of the respond number 2.
23. In 23.
Yes, madam, in 22. In Musharraf.
In item 22, he is filing.
I'll file reply to the counter filed by the respond number 2.
Item number 6, Mr. Abedin submits that he will file his reply to the affidavit in opposition file as a respondent authority. In item number 23, you take down of this matter along with WPC number 4498/2024.
My lord,
Parts are there, shall continue.
Item 24.
Deeply obliged, ma'am.
May it please us, my lord. This matter pertains to my lord, non-payment of salary to the petitioner, my lord. Petitioner is a my lord assistant teacher, my lord. And the salary has not been paid since April 2018. So if my lord comes to my lord order dated 89/2025, where they had sought for time for filing additional affidavit, my lord. Already one affidavit has been filed. They wanted to file again, my lord. So it.
I'm a third class PC matter. Or should we require some time as last opportunity, madam? Sometime maybe. We are still reconstructing our files, madam. We have been newly appointed.
May I pray one thing, my lord? Let it come in the next Tuesday, 18th. Where my lord, the matter may be disposed of, my lord, because the petitioner is about to retire in this month, my lord. Last week of November, he is going to retire, my lord.
Monday, let her fight after.
My lord,
Next Monday,
next Tuesday, my lord.
Tuesday.
Tuesday, my lord.
Or Mr. Iqbal, learned counsel for the petition. Miss, your name, please?
Bora.
Learned counsel, appearing on behalf of.
PTC matter, respondent.
PTC, respondent number 3.
Respondent number 3. Bora submits that she may be granted last opportunity to file the affidavit. There is accordingly allowed. Last opportunity is granted to Bora to file affidavit in opposition. Move the matter on next Tuesday.
Worship respondent number 348.
Number 345.
Deeply obliged.
Yeah. I am appearing for 3, 4, 5, and 6 respondent number. 3, 4, 5, and 6 in item number 25. Item number 25. 25. Today we have filed affidavit in opposition. Today, you received the copy. Yes. And as regards to item number 26, we need some more time. Pardon? We need some more time to file. Even in regards to item number 26. 26. Part Mr. Professor Learned Counsel for the Mr. T. Sharma. T. Sharma, Learned Counsel for the respondent number T 4, 5, and 6. Item 20. 25. Mr. Kyle for respondent number 7.
We file our application. Pending that we all the applications already start. And we have no role to play.
So your name has to be spelled out. That is your pair.
That can be done, my lord.
Okay. Mr. Bhuya for 1 and 2. Mr. Kyle Learned, Pending Counsel for the respondent number 7. Submits that no relief is being claimed by the petitioner against the respondent number 7. And as such, the respondent number 7 is not a proper party or formal party. And as such, the name of the respondent number 7 that is struck from the array of business. As the progress of submission, he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that the name of respondent number 7 is struck from the array of Recessal is the matter after 3 weeks.
It will come on the first week of December, my lord. Any date in the first week of December.
On 5th December.
Obligation.
Second item to take down art Mr. Professor Learned Counsel for the petitioner. And Mr. For respondent number here. In 26. 3, 4, and 5. 3, 4, and 5. 3, 4, and 5. Mr. Bhuya for
1, 2.
1 and 2. 1 and 2. You for respondent number 8. Here there is no respondent number 8. Only 6 respondents are here. The learned dissenting counsel for the respondent number 3, 4, and 5. 3, 4, and 5. Submits that he may be granted 3 weeks time to file the affidavit in opposition. They are allowed, that's it, the matter of the case.
Bless.
In this case, also we have filed an interlocutory application for modification of the interim order. The lawsuit by an interim order had directed us to pay 2 months salary. In fact, he is not entitled for this 2 months salary because this claim is for the month of June 24. We have already paid to it. And February 25 is not entitled because
No, whether any document is enclosed here. In respect of payment of salary for the month of
yes, I
February,
have annexed in my lawsuit.
page number
Here comes our
17 lordship.
17.
17 lordship of the IA lordship.
7.
This is for the month of June.
June 20.
And
February
other
25.
month?
February 25 also, he was not present for 100 because he has an in-house notice, their own arrangement. One should remain present for 100 hours. The entire month. He did not have the 100 hours.
My lord, to this I have one
Yes.
respect.
Do you have any documentary proof to establish the same?
Copy of one again. Lord, I have not received the copy of this, my lord. The records, it's not a part of the records, my lord. That is why I couldn't furnish a proper reply to this.
So then you file an additional affidavit bringing up record.
I can provide it right now. This.
My lord, I would like to file a counter to that because I have some humble submissions to that.
I can provide it.
Or Mr. Das declared counsel for the applicant. And Mr. Sharma for the respondent, opposite party,
One, my lord.
opposite party, number
One.
Mr. Punya for respondent number 2, 3, 23, and you for what university? Respondent number 5, UGC. You, respondent number 4. This application under Article 226. Implement 3 of the Constitution of India is referred to the applicant for citation, alteration, and or modification of the order, expertise interim order dated 20th 2025. Last name WPC number 4794 of 2025. Mr. Das clerk counsel for the applicant submits that the interlocutory interim order dated 20th 8 2025 is required to be modified as the respondent authorities have already paid the salary for the month of June 2024 to the petitioner, and he is not entitled to salary for the month of February as he was not present in the court for 100 hours.
Less than 100 hours. Here only 80.24.
He was present in the court for less than 100 hours. 100 hours. Mr. Sharma learned counsel for the opposite party number 1 submits that a copy of the document produced before the court today by Mr. Das may be furnished to him. And he also submits that the applicant may be directed to bring on record the said document by filing an additional affidavit so that the petitioner can respond to the same. Accordingly, taking note of the submission, it is provided that Mr. Das file an additional affidavit bringing on record the letter of the principal and secretary, Jagiroad College, dated 39/2018. 39/2018.
My. This document also.
Yes.
For the month of February.
But the letter is updated 39/2018.
That is an instruction.
My lord, then that is backdated because this occurrences happened recently. 18 or later.
Also computer generated thing. We cannot manipulate anything.
Okay.
Okay, I have already provided him a copy. Available, I can file an additional affidavit.
Monthly performance report dated 1/2/2025 to 28/2/2025.
And he should have come before this court, giving a
list on.
My lord, I also have one more prayer, my lord. My lord, since my attendance is in dispute, only if it pleases my lord, regarding that month of February 25, the original records may be called for. Because my lord, my instructions from my client is that he had more than 100 hours of working, my lord, which the respondents are disputing.
You first go through the.
Yes, my lord, yes.
Go through the
Yes,
documents.
yes, ma'am.
then inspect
Yes, ma'am.
here.
Your lawsuit has directed me to file an additional letter.
Yeah.
My
Okay,
lord,
I will do that.
my lord,
Bring it on
interim,
record.
Bring this.
my lord, interim order passed earlier may continue kind of.
Okay, if WPC. Art research.
In June 24 month has already been released. It should have come with a correct statement.
That was released in the month
He
of,
should have known also. He have got his money in the account.
that was provided in the month of September 24. That is why the confusion arose, my
Yes,
lord.
so this
I'll
matter
bring
was
it, my lord.
in the main, the interim order falls earlier self-completed.
I'm deeply obliged.
May I please, Lordship? Lordship, may I kindly give a look to the order passed on 26/9/2025. Yeah, it's an exit.
Lordship, I bring from the date.
Why?
Inspection.
The inspection we are not, for the first time we are the council appearing. But that should not be a ground, but I pray for some time to the technical instruction.
Art is P border, learned council for the page. Oh yeah, learned council.
There is a matter picture.
Standing council for the respondent DPC. It's Goya submits that she appeared for the first time here in this case. And she may be granted some time to obtain necessary extraction. Here is allowed.
28 November. Item 40.
Please, Your Lordship. Let's say 2 weeks time may be given to file our reply affidavit filed by the respondent number 2.
Art miss.
K. Borua.
A Borua, learned council for the petitioner, Mr. Yusama for the complaint secretary to the department. Is Borua for finance. Respondent number. The learned council for the petitioner submits that she may be granted 2 weeks time.
Lordship.
2 weeks time to file a reply to the affidavit in full filed by the
Respondent number 2.
respondent number
2.
Where allowed, this is a list of matter after 2 weeks.
41.
Okay, sir.
And in this, I have not received the instruction letter. May I say this matter will take up on Friday?
Friday.
Subsistence allowance not yet given, your my lord.
Pardon?
Subsistence allowance till today they have not paid your lordship to the petitioner. 3 months has already elapsed. Now it is 4 months running. How he will survive, your lordship will say. And they have not reviewed and extended the suspension order. They have not passed any order till then.
Whether it is passed. I do not know, but that's why I'm saying that.
No, you can obtain verbal instruction. You can obtain verbal instruction.
My lord.
Or tomorrow, madam.
If they have not reviewed the matter, extended the matter for suspension order, so there is lots of decision, also Supreme Court decision also in poll cases. My lord, your lordship will well versed regarding that. There is a judgment also, your lordship, several judgments.
Yes, I don't know whether it was reviewed or not. For that instruction, madam, on Friday or madam, day after tomorrow.
2 times they have taken the adjournment, your lordship.
Day after tomorrow then. Art Mr. and Sodore learned council for the petitioner. Miss Tia learned standing for the respondent secretary education. The elementary education department. Then Mr. Medhi for respondent number 7. Respondent number 7. Anybody for respondent number 3? District Commissioner Vishwanath. You are. Mr. Theory for respondent number 3. Ms. Sutia submits that she could not obtain instruction as to whether the suspension order of the petitioner is reviewed within the period of 90 days or not. And as to whether subsistence allowance was paid, allowance is paid to the petitioner or not. She tried for listing the matter on Thursday. They are allowed to submit the matter on Thursday or Wednesday.
Maybe it's
Wednesday,
Thursday.
day after tomorrow.
Wednesday. Master.
For bail hearing, item number 29.
May it please your lordship. Lordship, in this matter, we filed an additional affidavit.
Hmm.
I
When?
could not find, maybe it is not tagged with the records yet.
Not take with the record.
Lordship,
But
I could
when
not
did you
find it.
file it?
It has been over a week, lordship.
Is your name, please?
And Sultana.
And Sultana learned counsel for the accused. And also her is
And
learned counsel appearing on behalf of Sir S.P. Kare, representing counsel for NCB. The learned counsel for the accused subscribed. An additional affidavit has been filed a week back, but the same has not been taken with the record. Accordingly, it is provided that this is a list of matter on
Tuesday or Friday?
On 18.
18. And take the affidavit, additional affidavit filed by the accused along with the record.
Item 42.
May I please, your lordship? My lord, in this case, lordship, the petitioner is behind the bar for 3 years, 6 months, 25 days, lordship. My lord, first bail application that was rejected by your lordship will find at page 69. This was, lordship, rejected on 4/2/2019, 25. And your lordship may kindly take paragraph 4, 8, and 9 of the earlier order, page 69.
So,
My lord, up to that, lordship,
this is under Unlawful Activities Prevention Act.
my lord. Yes, lordship, altogether, lordship, 8 witnesses have been examined. And earlier occasion, lordship, at that time, 5 witnesses were examined. Nobody has named the lordship to the present petitioner. And subsequently, 3 witnesses have been examined. These 3 witnesses also has not, lordship, implicated the present petitioner. Altogether, lordship, 8 witnesses have been examined out of 25. Last witness was examined on 31/7/2025. Subsequently, lordship, several dates were made.
Mr. Khan,
My lord.
question is whether the other witnesses has the deposed anything against you or not.
Yes, lordship,
My lord, voluminous case diary, my lord, I have already most of the pages are blank, my lord. In fact, my lord, I tried to find out the deposition of the witnesses, my lord. My lord, I have not found those, my lord, regarding the, my lord, deposition of, my lord, as submitted by my learned friend, deposition of PW 8 and 9.
Whether those depositions
Yes,
available with you.
I have annexed lordship, page 39 onwards. Lordship, subsequent 6.
All the 8 witnesses.
Yes. Initially, lordship, 5 witnesses was examined.
Mr. Kotakar, you have received a copy of this petition.
Now, my lord, 2 witnesses he submitted that regarding 8 and
8 witnesses. My lord, first bail application was rejected at that time, lordship, 5 witnesses were examined. That was on 4/2/2025. And subsequently, 3 witnesses, PW 6, 7, and 8. Lordship, that 6, your Lordship will find at page 56.
Regarding this, my lord, I would like to point out by considering the gravity of the offense, earlier your lordship rejected this bail petition, my lord. And while considering the earlier bail petition, your lordship has discussed regarding all these points, my lord. Now regarding long incarceration, my lord, on that ground also, my lord, he will have to satisfy, my lord.
Yes.
43 AD, my lord, of the UAP Act, my lord, regarding whether he is, my lord, immediately after, my lord, release, whether he will be again, my lord, there are again commit,
Not I am relying to
involved in
judgment of the
committing
Honorable
this type
Supreme
of
Court.
offense again, but because, my lord, in this case, my lord, considering the gravity of the offense, he is a member of the Ansarul Bangla, my lord, and close associate of the, my lord, Al Qaeda of Indian continent. So, my lord, considering there are sufficient material against the accused persons, my lord, how he harbored some Bangladeshi nationals are also, my lord, they are along with the accused persons, my lord, in this case, my lord, how these accused persons involved in harboring those, my lord, accused persons, there are materials against the present petitioner, my lord.
My lord,
So considering all, my, I would like to point out one another aspect, my lord. Here, one of my friend has argued in this matter, that matter is pending before the coordinate bench of this honorable court. He has challenged the maintainability of the present bail petition wherein UAPA Act, my lord, regarding these sections are involved, that these are scheduled offences under, my lord, NI Act. So his argument at that point of time that, my lord, as because these offences, although, my lord, tried by the special court or the session court, these are scheduled offences under the NI Act. So, my lord, provisions of the NI Act, my lord, appellate provision of the NI Act is, my lord,
No, this case is not under NIA.
not under the NI Act, UAPA. In that case also, my lord, your lordship may be investigated by the state investigating agency, my lord. That regarding that aspect, that matter is pending before the coordinate bench of this honor on 12. So my prayer before your lordship may kindly peruse this order. My lord. After your lordship may allow 10 days time so that.
No. My lord, main witnesses, altogether 8 witnesses have been examined. None of the witnesses, lordship, have been examined. Your lordship has already recorded in the earlier order.
His argument
Up to 5
is that, my lord,
witnesses.
this bail petition is
3 years, 6 months, 25 days. Sir. Long incarceration, lordship.
long incarceration also, my lord, cannot be a ground.
No.
For releasing this
Why
type
not? Subsequently, several dates were given. None of the witnesses have been examined. I have annexed all those orders, lordship.
These are offences.
Subsequent orders.
Ultimately, what would be the result of that, my lord, bail petition? It is difficult for me to say. But,
Oh,
my lord,
yeah. Important witnesses, lordship, have already been examined. Now, subsequent witness, lordship, what they will say.
No, this present case is not registered under the NIA.
Yes.
not registered under the NI Act, my lord, investigated by the state, my lord, investigating is in that case also, my lord, because UAPA Act is involved, my lord, those sections are there. So those sections are scheduled offences under the NI Act.
Maybe.
So, my lord, because of that, that is the argument, my lord.
No, both are different acts.
Yes, both are
One
different.
is NIA Act and other is Unlawful Activities Prevention Act.
Yes. So, my lord, that's because, my lord, regarding that aspect, maintainability question is, my lord,
I don't think that this
Well,
argument has any merit.
yes, well, ultimately, whether that will be a result, what would be the result of that bail petition, I do not know, my lord. So let the matter may kindly fix after 10 days, my lord. On that point, if my lord any.
Lordship, I have given one latest judgment. Your lordship may kindly see.
And regarding, my lord, length of my lord, long incarceration, your lordship, my lord, Tarun Kumar of the Supreme Court judgment, it is very clear that in, my lord, length of detention cannot be a ground, my lord. And regarding in this case, these are, my lord, consider, my lord, these offences are, my lord, offences against national
Not only
security.
length of detention, what they have
They are the
done. lordship.
members of Ansarul Bangla team, how he harbored, how he is, my lord, involved. There are materials. my lord.
No, is there any implication by the witnesses that I have an express the
Till now,
main
only 8 witnesses
deposition
are
of the
there are
witnesses
some-
up to
No,
it's
Mr. Khan,
lordship.
the witnesses examined till date have not implicated you. That is a different aspect. But the witnesses who are yet to be examined.
Yes.
Whether there is any material in their statement before the police or not, that has to be looked into.
That is to be lordship, but your lordship will see PW 1 to 8. These are the main witnesses, lordship. The witnesses are involved in this case.
Not only.
But
witnesses,
none of the
electronic
witnesses has
evidence is
implicated.
also there, my lord.
If
Electronic
your lordship
evidence
kindly
is
come to
there.
the judgment,
Mr. Khan, be
Yes.
logical.
and so,
45 witnesses have been cited.
yes,
Only 8 have not implicated you.
yes.
But whether the other witnesses will implicate you or not, can we say at this stage?
My lord, absolutely I cannot say because, but main witnesses, lordship, vital
We have to
witnesses.
see their statement before the police under section 161
No.
CRPC.
No, these witnesses are lordship not implicated. They have, before the lordship, eye of the case. My lord,
What is the latest judgment?
my lord, judgment, your lordship may kindly take 2021, 3 HCC 713, K.A. Najib judgment, lordship. Paragraph 17, 18 and 19. Lordship, I have given the two judgment. These are relating to unlawful activities prevention act, lordship. Paragraph 17. It is thus clear to us that presence of statutory restriction like section 43D5 of the so and so act per se does not out the ability of the constitutional court to grant bail on the ground of violation of part 3 of the constitution. Indeed, both the restriction under a statute as well as the power exercisable under constitutional jurisdiction can be well harmonized. Whereas at commencement of proceeding, the courts are expected to appreciate the legislative policy against grant of bail, but the rigors of such provision will melt down where there is no likelihood of trial being completed within a reasonable time, and the period of incarceration already undergone has exceeded a substantial part of the prescribed sentence. Such an approach would safeguard against the possibility of provision like 43D5 of the so and so act being used as a sole metric for denial of bail or for wholesale breach of constitutional right to speedy trial. Adverting to the case at hand, we are conscious of the fact that charges level against the respondent are grave and serious threat to societal harmony. Had it been a case at the threshold, we would have outrightly turned down the respondent prayers. However, keeping in mind the length of the period spent by him in custody and unlikelihood of trial being completed anytime soon, the High Court appears to have been left with no other option except to grant bail. An attempt has been made to strike a balance between the appellant's right to lead evidence of its choice and establish the charges beyond any doubt, and simultaneously the respondent's right guaranteed under Part 3 of our Constitution have been well protected. Yet another reason which persuades us to enlarge the respondent on bail is that Section 43D5 of the so and so Act is comparatively less stringent than Section 37 of the NDPS Act. Unlike NDPS Act,
That is not the issue before this court now.
yes. My lord,
The question before this court is whether the witnesses who are yet to be examined have implicated you or not in their statement under section 161 CRPC.
my lord,
The copy of the statement have been furnished to you.
yes.
You go through it, you let the court know on Thursday. You also go through the statement
Yes.
of those witnesses who are yet to be examined. And you appraise this court on Thursday. Third, Mr. Unlearned counsel for the accused, Mr. Borfakur. Third, additional petition for the state contact. Third in part, lays the matter Thursday. So as to enable Mr. Borfakur, no, Mr. Khan and Mr. Borfakur to go through the statement of the witnesses recorded under section 161 CRPC as to whether they have implicated the present accused in the said statements or not. This recording.
And my lord, there are electronic evidence against the accused person is also there. Not
Whatever
only-
they are, you go through it.
Yes, yes.
13 November.
Not judgment, maybe kept on that.
You can take it back.
Lordship,
On that day, you can produce it.
Lordship, on that day, Lordship.
Item number 30 for orders.
Lordship, in this case, on last occasion on 2014, Lordship, they have placed instruction before the court that on 31/10/25 SLC meeting will be held and case of the petition will be placed before the meeting.
Yes,
So what happened in that
Our
meeting?
matter has been placed before the SLC on 31/10/2025. My lord, sometime is required to get the up-to-date instruction regarding that, what is the outcome of the SLC meeting. This is. Already
31/10
placed the-
already passed. Again, he is placing that letter, Lordship.
No, already placed the matter before the SLC on 31/10/2025, my lord.
No, on the last occasion also, Mr. Sharma, he has produced this letter.
Lord.
No, last occasion is about to place the matter before the SLSC on 31/10/2025 would have to be held, and now it is held on 31/10/2025.
Heard Mr. P. Sharma, learned counsel for the petition. Respondent. Part. Mr. Sharma, producing a letter of the Joint Secretary to the Doctor of Department of Security, dated 7/11/2025, that the case of the petitioner was placed before the SLC, which was held on 31/10/2025, and the result is awaited and he tried for the second after 1 week.
1 week. 10 days, my lord.
No time. Accordingly, it is provided that Justice shall raise the matter on 19th.
Lordship, on that day, they may be directed to produce the minutes also, Lord, of the meeting held on 31st.
Okay. Mr. Sharma shall also produce the minutes of the meeting of the SLC before the report of that day.
Obliged, Lord.
31.
May please, Your Lordship. Okay. Yes, sir.
Appointment to display of 9.
So Mullah,
My lord.
You have been furnished with a copy of this order?
No, my lord, I have not got this order, man. So,
You
on extra
furnish a copy?
copy may be given to me, and my lord, may I pray one thing, my lord? Let the matter come on a specific date, my lord. In the meantime, I will go through this, my lord. Today I am without goggles also, my lord. I
Okay.
cannot go through.
Art Mr. AFN.
Very, very noted.
Also for the content part. Sophia has produced order. The produced one hearing report. Along with one letter of the director. Dated 9/11/2025. Director of Elementary. Dated 9/11.
He is no more retired. Oh. That's when the area finish that has said.
And perusal of the same indicates that the claim of the petitioner cannot be considered. Some a copy of the order be furnished to him. So as to a copy of the hearing report and the letter of the director may be furnished to him.
No, I have already furnished my.
Just furnished.
So as to enable it to go through the same and to obtain instruction. Here is allowed recessal is the matter of 21st. The letter furnished before the court today shall be marked as annexure P and be taken with that.
Published.
Item 34.
Meet with the lordship. Here, my lord, there was some mistake in regards to filing, my lord. I have prepared a note, my lord. Your lordship can go for the. What happened, my lord? We have filed a IA. The numbering it is 3454-2025. This IA was wrongly connected with 4212-2024. And actually it should have been connected with WPC 4450/2024. In the meantime, the case 4212, this has been disposed of by this honorable court. So my simple prayer before your lordship, because if the IA that we have filed for some mistake, it has been listed there, so it should be directed to be listed in its proper WPC 4450/2024. As
My lord, we have committed a mistake in filing the IA. There we have said that it's, the name of the, connect, it should.
Mr. Raghuwai, you tell me. What is your pair in this IA number 3454?
3454. We are, that is also there in the first file, my lord.
So you come to page number 8 of the IA.
My lord. Under this circumstance, it is most respectfully prayed, the honorable could be pleased to admit this IA, and after hearing parties be pleased to allow to challenge the amendment regulation so and so, annexure B dated 15024. After hearing the parties be pleased to allow the amended provision of the regulation dated 15204, that is regulation dated 15204, and was the section 59 oblique within bracket 6 and or person. What happened, my lord? There, earlier the regulation was in the year 1990 or 2019. Subsequently, we have challenged it in the writ petition, but subsequently this new regulation has come. At phase 2, your lordship, phase 5, there are 2 standards. When this has come, we need to aid it and challenge it. That is why we have filed the IA to allow us to challenge that new regulation in the writ petition number 4450. Earlier, the regulation was in 2019.
Petition 4450 has already been disposed of.
No, 4450 is not disposed of. This 4212/2024, where it has been connected, that is before your lordship, that was disposed of in February 2025.
No, this IA, now you tell me what order is to be passed here.
Here only to connect this IA with your lordship 4450/2024.
No, where is your pair to that effect? Is it in your pair portion of the IA?
Pair, because my lord, the IA has been filed long back, so this question was not there.
Mr. Puragohai, better you withdraw this IA, you file it in proper format. And this making the proper pair.
All right, I will make.
You were submitting one thing, then in your IA, it is another thing.
I understand, my lord. Your lordship says that this IA be withdrawn and then we will file a new IA in that.
I will grant you liberty.
My lord.
Third, Sir Puragohai Learned Counsel, Senior Counsel, assisted by Ms. Learned Counsel for the applicant and Mr.
Bidas for the AG team.
Learned Standing Counsel for
I'm not the standing counsel, Mr. KP Patel is the standing counsel.
KP Patel.
Yes, madam, some medical emergency, that's why I'm appearing on the.
Learned Counsel appearing on behalf of Mr. KP Patel, Learned Standing Counsel
Yes, ma'am.
for AICT. AICT. The Puragohai submits that he may be permitted to withdraw his interlocutory application and to grant him liberty to file a fresh one.
In the proper WPC. It has been wrongly my lord done there.
Connection with WPC number
Uh,
40
um,
4450.
4450.
4450 of 2024. There is accordingly allowed. Granting liberty to Mr. Raghuwai, Learned Counsel for the applicant with interlocutory application stands his disposal on withdrawal.
Obligation.